if they're going to be able to stay open. They're not interested in all this hocus pocus, in this legislation that actually creates large opportunity for manipulation. Because anybody can challenge the regulation. You can open up another fake entity that's really designed to muck up the system. So I know that this is a talking point, right? Ooh, we're helping small business, but you're not by doing most of the stuff in here. And then you're gonna cut SBA? I mean, the Small Business Administration is actually one of the best tools for helping small business. It actually says it in the title. Job Corps and vocational training programs that are designed to get us a workforce that's trained to actually go into small businesses or open them, doesn't say anything about helping them. But this really does sort of give carte blanche to big entities with a lot of political, donor hustle to either work with a complicit administration or get incredibly and dispiritedly negative with one and try to break them for their own benefit. So we also should acknowledge that oftentimes small businesses are used as a pawn for the handouts that big business wants. And that's also what is part of this legislation. So on behalf of all the small businesses in my district, we all oppose this bill. Thank you, and I yield back.
Generally, bill. Those in favor say aye. Aye. Those opposed say no.
No.
In the opinion of the chair, the ayes have it, and the amendment in the nature of a substitute is adopted. The question is now on favorably reporting the bill as amended. Those in favor say aye. Aye. Those opposed say no.
No.
The ayes have it, and the bill is ordered to be reported favorably.
We have a recorded vote, Mr.
A
Chair.
recorded vote is requested. The clerk will call the roll.
Mr. Jordan, Mr. Isa, Mr. Biggs, Mr. McClintock,
Aye.
Mr. McClintock votes aye. Mr. Tiffany votes aye. Mr. Massey, Mr. Roy, Mr. Roy votes aye. Mr. Fitzgerald, Mr. Klein votes aye. Mr. Gooden, Mr. Van Drew, Mr. Nels, Mr. Moore, Mr. Kiley, Ms. Hageman. Ms. Hageman votes aye. Ms. Lee, Mr. Hunt, Mr. Fry, Mr. Grothman, Mr. Knott. Mr. Knott votes aye. Mr. Harris, Mr. Onder. Mr. Onder votes aye. Mr. Schmidt, Mr. Gill, Mr. Baumgardner, Mr. Raskin.
Nope.
Mr. Raskin votes no. Mr. Nadler. Mr. Nadler votes no. Ms. Lofgren. Ms. Lofgren votes no. Mr. Cohen. Mr. Cohen votes no. Mr. Johnson. Mr. Johnson votes no. Mr. Swalwell. Mr. Liu. Ms. Jayapal. Ms. Jayapal votes no. Mr. Correa. Ms. Scanlon. Ms. Scanlon votes no. Mr. Neguse. Ms. McBath. Ms. McBath votes no. Ms. Ross. Ms. Ross votes no. Ms. Ballant. Ms. Ballant votes no. Mr. Garcia. Ms. Kamlager-Dove. Ms. Kamlager-Dove votes no. Mr. Moskowitz. Mr. Goldman. Mr. Goldman votes no. Ms. Crockett. Mr. Jordan. Mr. Jordan votes yes. Mr. Massey. Mr. Massey votes yes. Mr. Baumgardner. Mr. Baumgardner votes yes. Mr. Schmidt. You're not recorded. Mr. Schmidt votes yes. Mr. Van Drew, you're not recorded. Mr. Van Drew votes yes. Mr. Issa, you're not recorded. Mr. Issa votes yes.
The clerk will report.
Mr. Chairman, there are 13 ayes and 12 noes.
The ayes have it, and the bill is ordered to be reported favorably to the House. Members will have 2 days to submit views. Without objection, the bill will be reported as a single amendment, the nature of a substitute, incorporating all adopted amendments, and staff is authorized to make technical and conforming changes. The gentleman from Maryland is recognized.
Thank you, Mr. Chairman. I have a UC request for 2 letters opposing H.R. 421, one from the Coalition for Sensible Safeguards, one from Earth Justice.
Without objection. Okay, pursuant to notice, I call up H.R. 589, the FACE Act Repeal Act of 2025 for purposes of markup, and move the committee reported favorably to the House. The clerk will report the bill.
H.R. 589.
Without objection, the bill be considered as read and open for amendment at any point. The chair now recognizes the gentleman from Texas, Mr. Roy, for an opening statement.
Thank the chairman. We've had this hearing today about talking about overcriminalization. This is another area in which I think the federal government has inserted itself in a way that has now been used and politicized and weaponized against people across this country, including people of faith, and is doing so with a very specific and biased political purpose. Enacted in 1994, the FACE Act was passed with significant debate, prohibiting threats of force, obstruction, and property damage intended to interfere with reproductive health care services. It also prohibits the obstruction of and damage to houses of worship. Yet the Biden-Harris administration disproportionately used the FACE Act to target pro-life Americans. For example, Biden's own Department of Justice provided FOIA data demonstrating that a mere 8% of the FACE Act cases filed under his administration were against agitators at pregnancy resource centers, with 92% being against pro-life individuals protesting at abortion clinics. I introduced the FACE Act Repeal Act, H.R. 5577, last Congress after witnessing how the federal government used the FACE Act as a pretext to go after pro-life demonstrators. And that is why I reintroduced the FACE Act, H.R. 589, in this Congress. The previous administration weaponized the FACE Act to prosecute nonviolent pro-life Americans with the harshest sentences. Through my office's review of federal data, the Biden Department of Justice brought almost a quarter of all the FACE Act prosecutions, 24% of all charges targeting pro-life activists in less than 4 years, turning a blind eye to the anti-life activists engaged in destroying, vandalizing, and even firebombing pregnancy resource centers and churches at the same time. Over the last 4 years, the Biden-Harris DOJ demonstrated their interest in catering to the anti-life movement, more interest than protecting facilities that assist pregnant women in need. While the Trump administration continues to take positive steps to remedy the damage inflicted by the Biden-Harris administration, it's not enough to merely end this one-sided enforcement of the law. This is why we're having a markup today in which we're talking about overcriminalization. I realize this issue is going to be hotly debated. I realize it is going to be seen as political. I'm trying to be clear that I have significant reservations and concerns about overcriminalization generally, about the federalization of these issues, the over-empowerment of the Department of Justice and those people in Washington, D.C., regardless of who is in power, regardless of who is in the White House. And I believe that the FACE Act was used politically and will be used politically again in the future. To be clear, I'm getting some resistance, even in our own administration, saying we can use the FACE Act for their own purposes, to target people specifically for varying views. Say, well, we'll use it to defend churches more, and we will not use it as politicized to focus on people at places where abortions are performed. But that's not what my goal is. My goal is to alleviate the politicization in the first place, is to reduce the extent to which the federal government is empowered to even do this. While the Trump administration takes those positive steps, I believe Congress must fully repeal the FACE Act to ensure future administrations are unable to weaponize this statute against peaceful advocates. There are many reasons why Congress should repeal the FACE Act, but here are 2 examples. First, the FACE Act is in significant contrast to our protections under the First Amendment. The First Amendment guarantees our God-given fundamental right to free speech and free exercise of religion without our government discriminating against our viewpoints. Attorney General Garland and President Biden's DOJ selectively enforced the FACE Act by prosecuting pro-life activists overwhelmingly and clearly, statistically significantly, more so than anti-life activists, allowing violent pro-choice demonstrators to escape prosecutions at alarming rates. This blatant prosecutorial discretion violated constitutional rights and was used to selectively target disfavored speech. Such selective enforcement is contrary to the rule of law, which demands equal application. Second, the Biden-Harris administration showed us how easy it is to weaponize the FACE Act to further partisan anti-life motives. After the Dobbs decision, the Biden-Harris DOJ called to increase the urgency of the DOJ's enforcement of the FACE Act to protect abortion access. The DOJ would rather focus its time and resources on going after pro-life grandmothers, sentencing them to years of federal prison for, at best, a trespassing charge, instead of targeting actual criminals who walk free for violent crimes. And by that, I'm referring to a literal grandmother who was put in prison for having sat at a abortion center and prayed. She was put in prison for years while sick for exercising her beliefs and her rights. In the wake of hundreds of churches and pregnancy resource centers being attacked, the Biden-Harris DOJ focused its resources on using the FACE Act against pro-life advocates peacefully exercising their rights and beliefs to defend the unborn, sentencing many of them to years of federal prison for, at best, trespassing charges instead of the actual criminals who walk free. In 2022, the Biden-Harris DOJ brought 26 prosecutions under the FACE Act, and all of them involved pro-life defendants protesting at abortion clinics. In 2022, the Biden-Harris DOJ brought 26 prosecutions under the FACE Act. All of them involved pro-life defendants protesting at abortion clinics. Perhaps the most egregious of these was Mr. Houck. In 2021, Mr. Houck was doing sidewalk counseling outside an abortion clinic. During the incident, a clinic volunteer began verbally harassing his 12-year-old son who accompanied him that day, which led to him to push the belligerent volunteer escort of the abortion clinic away from his son. After local authorities declined to press charges, the Biden DOJ stepped in, dispatching a team of FBI agents to arrest Houck at gunpoint during a pre-dawn raid in front of his terrified wife and children. The Biden-Harris DOJ charged Houck with 2 counts of violating the FACE Act. Houck faced 11 years in federal prison if convicted. Thankfully, a jury rightfully and swiftly acquitted Houck on all charges, but many such defendants are not as fortunate. At a hearing in my subcommittee last December, we discussed the stories of Paul Vaughn, Lauren Handy, by the way, who is a progressive activist, Eva Idle, who survived concentration camps in Europe, and Paulette Harlow, the grandmother to whom I was just referencing, going to jail. The FBI raided Mr. Vaughn's home, arresting him in front of his wife and 11 children for praying outside of the clinic. The Biden-Harris DOJ prosecuted Mr. Vaughn and sentenced him to 6 months of home confinement and 3 years of probation. Juxtapose Mr. Vaughn's and Mr. Houck's cases with those of anti-life individuals. In 2023, the Biden-Harris DOJ prosecuted 4 individuals for spray painting threats on Florida Pregnancy Resource Center. 3 of these activists received 30 days in prison. The politicized nature of these prosecutions cannot be ignored. H.R. 589 eliminates the possibility that everyday Americans can face felony convictions for peaceful acts such as sidewalk counseling or singing hymns. Passage of this bill is a crucial and necessary step. To be clear, it does nothing to undermine existing state laws, does nothing to undermine the ability of local and state prosecutors to enforce the law in their communities as appropriate, does nothing to undermine the ability to use other federal laws when you're engaging in criminal enterprise across state lines if you're engaged in that behavior. There are plenty of other ways to go after and prosecute individuals who are carrying out dangerous acts of violence. And certainly you can do it at the state level and the federal level. But having a statute such as this in place is begging for it to be politicized. It was politicized, and Americans have been put in prison as a result of their beliefs, and it should not remain in place. And with that, I yield back.
Gentleman yields back. The ranking member is recognized.
Thank you very much, Mr. Chairman. Here's the danger of making legislative decisions based on anecdotes or single cases, because I had not heard about the alarming case of the grandmother who was sentenced to 2 years in prison for praying outside a clinic. When I entered that into the search, what I got back was claim a 75-year-old woman named Paulette Harlow was sentenced to 2 years in prison for praying outside an abortion clinic in Washington. AP's assessment false. Harlow was convicted in August 2023 of federal civil rights offenses for her role in the October 2020 invasion and blockade of the Washington Surgery Clinic. Along with other activists, Harlow used force and physical obstruction to execute the blockade, according to the Department of Justice. So, I mean, I don't know all of the details of that one. Obviously, there's no grandmother exception to this statute or any other criminal statute that I'm aware of, but it doesn't sound like she was arrested for praying or put in jail for that reason. But look, let's grab the bull by the horns and look at what is really at stake in this statute and in this legislation. We're here to consider a bill that would repeal the FACE Act just weeks after a self-described pro-mortalist suicide bomber targeted an IVF clinic in Palm Springs, California. While only the bomber died in that particular attack, the episode reminds all of us of why the FACE Act is necessary, why it was passed in the first place, and why repeal will be dangerous. The FACE Act draws the line between protected First Amendment expression, whether it's speech or writing or praying, and unprotected violent conduct and physical obstruction. This is a proper exercise of congressional authority. This is why no challenge to the FACE Act has ever been accepted by the Supreme Court, and the act has been repeatedly upheld as constitutional by every single federal circuit court asked to consider the constitutionality of the law. The FACE Act prohibits the use or attempted use of force, threats of force, or physical obstruction intended to injure, intimidate, or interfere with the obtaining or provision of reproductive health services, or similar interference by force or obstruction with religious free exercise at a place of worship. The term reproductive health care services covers all reproductive health care providers, which includes also IVF facilities, like the one that was recently targeted, as well as anti-abortion counselors operating in the self-described pro-life pregnancy centers. Congress passed the FACE Act in 1994 after a wave of violent blockades, attacks, and obstruction of abortion provider facilities that culminated in the murder of Dr. David Gunn and the shooting of Dr. George Tiller, who years later was actually murdered by an anti-abortion activist while attending church services in 2009. And it's not just murder that the FACE Act covers. It protects patients and providers against non-lethal violence and physical obstruction. Just last year, the DOJ obtained a conviction against defendants who had physically blocked a patient from getting into a clinic, from entering a clinic in Sterling Heights, Michigan. The patient and her husband made an appointment at the clinic after learning that their fetus suffered severe fatal abnormalities and that continuing the pregnancy carried serious risks to the mother's health and future fertility. Yet the defendants physically blockaded her from getting the health care that she so desperately needed, surrounding her car in the parking lot and trapping her helpless in her car for several hours. On its terms, the statute deliberately covers violence and obstruction directed not just against clinics, but also against churches and also against all types of reproductive facilities, including the pro-life pregnancy centers. Despite claims to the contrary, the Biden administration did prosecute FACE Act cases involving obstruction at so-called pro-life pregnancy centers. Just last year, DOJ obtained a conviction against a defendant who spray-painted several pregnancy centers with threatening messages, including, "If abortions aren't safe, then neither are you." The FACE Act is completely viewpoint neutral in its textual scope and viewpoint neutral in its application. If more people have been convicted of attacking pro-choice abortion clinics than have been convicted of attacking pro-life pregnancy centers, as my friend from Texas suggests, it is because there have been vastly more people attacking abortion clinics than attacking pregnancy centers. And obviously, it would make no sense as a matter of law to make up cases that don't exist or not to prosecute cases that do exist to somehow even the score. That's not how we think about the law. We punish actual acts that people engage in and not political philosophies. Yet, some of my friends are so committed to, and I don't include my friend from Texas, but others are so committed to a self-pitying victim politics and so committed to signaling permission for vigilante anti-choice extremists that they're pushing the repeal of a critical public safety law which protects them, just weeks after what the FBI described as an intentional act of terrorism that took place against a FACE Act protected facility, an IVF facility. That act of terrorism isn't isolated. According to the National Abortion Federation's 2024 report, the Dobbs decision has emboldened anti-abortion extremists, with NAF finding, quote, an immediate spike in major incidents targeting abortion providers, including arsons, burglaries, and death threats. The report noted that extremists are traveling, even moving to states where abortion remains legal, and proceeding in those states not just to protest, which is perfectly constitutionally protected, but to intimidate, harass, and attack abortion providers to interfere with people's access to abortion care. The people targeted by the FACE Act are not peaceful protesters praying outside a clinic and not blocking access. If they were such people, they would be completely protected from a criminal prosecution. In fact, even menacing protesters are still protected. For example, if you look at the man in this photo, a protester armed with an actual assault weapon standing outside of a clinic in Michigan, where the right to medical abortion is protected by the state constitution, even his form of protest, as threatening as it may appear to be to patients and passerbys, does not violate the FACE Act. It was never prosecuted because he was not engaged in violence or a direct threat of violence, nor was he engaged in physical obstruction. So whether you're praying or you're actually carrying a weapon, that in itself does not come within the prohibition of the law. Repealing the FACE Act is part of the long-term plan to achieve the long sought after and extremely unpopular goal of effectively banning abortion nationwide. While a series of stinging defeats in statewide ballot questions have caused our GOP friends to downplay for now their dream of a nationwide ban, a majority of them signed on to a ban with Speaker Johnson just a few years ago. And they continue to do whatever they can to restrict and obstruct women's physical access to abortion, regardless of the effect it may have on their health and safety. As one anti-abortion activist said over 30 years ago during debate over passage of the initial FACE Act, we may not get laws changed or be able to change people's minds, but if there's no one willing to conduct abortions, there are no abortions. If the FACE Act were repealed today, extremists would be further emboldened to obstruct and attack abortion providers and facilities and to intimidate both doctors and patients. Indeed, that onslaught has begun. On the Senate side, Republicans are in the midst of advancing a budget bill to defund Planned Parenthood. President Trump's HHS Secretary RFK Jr. directed the FDA to review regulations for mifepristone, the most widely used medical abortifacient drug. And a pregnant Georgia woman who was declared brain dead remains on life support against her family's wishes and is being used as a human incubator because of that state's abortion ban. Today's effort to overturn the FACE Act follows President Trump's use of the pardon power to grant pardons and clemency to nearly 24 people convicted of FACE Act criminal violations, including the defendants I just mentioned, who trapped a woman in her car for several hours to stop her from seeking the medical care she needed. Political reports that several of the other defendants pardoned by Trump have said that they plan to go into abortion clinics, either by force or stealth, to block women from getting health care services. The DOJ has recently announced a policy pulling back on enforcement of the FACE Act by limiting abortion-related prosecutions only to cases presenting extraordinary circumstances or in cases presenting significant aggravating factors such as death, serious bodily harm, or serious property damage. They're essentially putting the statute into an administrative straitjacket so MAGA in Congress can give it the legislative guillotine. The administration is sending out disturbing signals when it comes to violence against women. It's cut millions of dollars in grants, as we've discussed, Mr. Chairman, that would have supported the victims and survivors of sexual and domestic violence. It jumped to provide aid and comfort to the Tate brothers, misogynist manosphere social media influencers, when they were charged with rape in Romania. It pardoned nearly 1,600 rioters and insurrectionists from January 6th, including Stephen Randolph and Ryan Sammel, who violently assaulted a brave female police officer, U.S. Capitol Officer Caroline Edwards, with a metal barricade. So the common denominator is that we're not paying attention to the real needs of women or public safety. We're doing everything we can to curtail their rights. I urge my colleagues to vote no on H.R. 589 to oppose violence and obstruction in all its forms and guises, to protect the safety of the American people, and to resist continuing efforts to enact a nationwide ban on abortion. I yield back.
Without objection, all other opening statements will be included in the record. The chair now recognizes the gentleman from Texas to offer an amendment in the nature of a substitute.
Mr. Chairman, I have an amendment at the desk.
Clerk will report the amendment.
Amendment in the nature of a
Without
substitute.
objection, the amendment in the nature of a substitute will be considered as read and shall be considered base text for purposes of amendment. The chair now recognizes the gentleman from Texas to explain the amendment.
Mr. Chairman, this amendment removes the year from the title of the bill. It is not intended in any way to alter the substance or important purpose of this bill. I urge support for my amendment. I yield back.
Gentleman yields back. Who seeks recognition? Gentlelady from North Carolina is recognized.
Thank you, Mr. Chairman. Before the enactment of the FACE Act, doctors and patients seeking reproductive care had to physically push their way through threatening crowds to reach clinics. They had protesters stick pins in their legs, pinch them. They faced threats of arson, found their homes picketed, and dealt with frequent death threats. When the FACE Act was enacted, patients and providers found that this intimidation decreased significantly because those harassing doctors and patients and interfering with clinic access knew they could be prosecuted. The FACE Act prohibits conduct, not speech, which is why multiple federal appeals courts have found that the law does not violate the First Amendment. The FACE Act works. And the sad thing is, that's why Republicans on this committee are so intent on repealing it. They want doctors to be so intimidated that they cannot do their jobs. And they want patients to feel unsafe seeking care so that they will give up entirely. Imagine if those of us in this room faced the same intimidation and threats as we went to work to do our jobs as doctors and patients feel when they didn't have protection from the FACE Act. Imagine if protesters surrounded the Capitol and stuck pins in our legs when we tried to go to the floor to vote. Imagine if we had to push through walls of people blocking House building entrances to get to a hearing or markup. We wouldn't let that stand. The Capitol Police would be on the scene to disperse the crowd within minutes. And DC and federal prosecutors would charge anyone who intentionally injured or intimidated or interfered with our work. Why do we deserve more safety than women exercising their rights and doctors providing care? These are basic health care actions. We have got to protect people. The only reason we have, for the most part, escaped the same kind of threats and intimidation is because people know that they would be prosecuted. Now, they might be pardoned, like our president did, but they will be prosecuted. The FACE Act works because it tells people that they will be prosecuted if they intimidate and threaten doctors and patients. These doctors and patients can't always rely on police and local prosecutors to come to their aid because of politics. Threats to reproductive health centers, even those that do not provide abortion care, are on the rise. This is evidenced by the bombing of an IVF clinic in Palm Springs just a few weeks ago. The best way and the proven way to address this behavior is to ensure people know that the federal government itself can and will prosecute those who threaten the safety of patients and doctors. The FACE Act must stand for the good of public health, for the good of women seeking necessary care, and to protect our healthcare providers. And I, too, join my colleagues in commending the work of Planned Parenthood. I live right down the street from a Planned Parenthood in Raleigh, North Carolina. Thank you so much for being here to petition the government for redress of your grievances. And I yield back.
Gentleman yields back. Gentleman from Missouri is recognized.
Thank you, Mr. Chairman. I commend my colleague Chip Roy for bringing forward this long overdue piece of legislation. When the FACE Act was passed in May of 1994, a number of members of Congress warned about the potential unintended, or I would argue intended, consequences of the FACE Act. Congressman Chris Smith warned that the House is poised to stack the deck against peaceful pro-life activists so as to make them prey and easy mark for ruinous prosecution and civil suits. Senator Dan Coates warned that the legislation singled out the pro-life cause for harsh penalties that would not apply to other causes engaged in similar conduct, and that it would, quote, chill core First Amendment free speech to lawfully protest abortion. How right they were. The Alliance Defending Freedom has pointed out that the FACE Act, on paper, protects pro-life pregnancy care centers as well as abortion clinics. But you would never know it. In 2022, the Department of Justice brought criminal charges against at least 26 pro-life individuals under the FACE Act. Meanwhile, there were over 200 acts of vandalism against pregnancy care centers and churches since Roe was overturned, but almost no charges were filed. And clearly the Biden-Harris administration has engaged in thuggish, intimidating behavior against peaceful pro-life activists, including Mark Hawk and Paul Vaughn, both being arrested staring down the barrels of pointed guns for, at worst, trespass. And in 2023, the Biden DOJ indicted 8 pro-life activists, including 87-year-old Eva Adele, a communist concentration camp survivor, for protesting at an abortion clinic. Since 1994, 97%, I repeat that, 97% of FACE Act prosecutions have been against pro-lifers. It is time to end the weaponization of the FACE Act against peaceful First Amendment protected speech. The FACE Act was a bad law when it was enacted, and it's time to repeal it. I proudly support H.R. 5890. I yield back.
Gentleman yields back. The gentleman from New York is recognized.
Thank you, Mr. Chairman. Back in 1994, I was one of the authors of the FACE Act. I was right then, and we're right now. And the slanders against the FACE Act today are simply not true. Praying is not prohibited by the FACE Act, unless while praying you are physically obstructing access to an abortion clinic, or for that matter, to a pregnancy crisis center, or to a church. It doesn't matter. The Act goes all ways. But the key thing is the use or threat of use of physical force. Now, the gentleman from Texas said that 92% of the prosecutions were for abortion clinics and only 8% for pregnancy crisis centers. Well, that may simply show that 92% of the crimes committed were against abortion clinics and 8% against pregnancy crisis centers, which would not be surprising since we know that there were 2 murders in connection with abortion clinics. We are not aware of any murders in connection with pregnancy crisis clinics. The gentleman said that this inhibits First Amendment rights. No, it doesn't. First Amendment rights are speaking or advocacy. Now, if you're speaking and advocating while physically blocking an abortion clinic, then the FACE Act acts, not because of your speech or advocacy, but because of your physical blocking. That's what the FACE Act prohibits. That's what we still need prohibited, because abortion clinics are still threatened. Sometimes pregnancy crisis clinics are also threatened. Either one, both of them, if threatened, both classes, I should say, if threatened, should be protected, and that's what the FACE Act does. An attempt to repeal the FACE, if the FACE Act were repealed, you would return to the situation before you had it, where you had physical violence in front of abortion clinics. We do not want physical violence in front of abortion clinics, or for that matter, anywhere else. That's why we must keep the FACE Act on the books, oppose this legislation, and defeat it.
Well, gentlemen, yield.
I'll yield to the gentleman.
Thank you very much, Mr. Nadler. The last point you landed on is a very powerful one, which is, I understand that we've got millions of fellow citizens who want to end abortions in America. So how can they do it? Well, you could come to Congress and try to pass a national law. This is what Speaker Johnson wanted to do with his Life Begins at Conception Act. I suppose a lot of our colleagues on the committee are on that. They don't have a majority in the House of Representatives to do it, and they don't have a majority in the Senate to do it, I don't think. So they can't do that. Then they could do what civil social change movements have done in American life forever, which is to try to engage in moral persuasion, to try to convince people don't have an abortion, to write letters, talk to people, counsel, and so on. But they don't want to leave it at that. They want to try to actually intimidate people, to obstruct people's access to clinics, to violently shut them down. Some people have tried to bomb clinics and bomb clinics. Some people have killed doctors who provide abortion services. And so the FACE Act was passed, and you were here, and most of us were not, Mr. Nadler, but the FACE Act was passed in order to make it a federal offense to use violence or obstruction against people exercising a constitutional right. Now, it's not a constitutional right because of the Dobbs decision, but it is a constitutional right in the states that permit it to happen, and it's health care. And so people have a constitutional right to exercise their health care options. And so I can't understand for the life of me why, whether you call yourself pro-choice or pro-life, you would want to have scenes of violence and obstruction taking place in front of abortion clinics or other reproductive advice clinics or churches. And I yield back.
Reclaiming my time, there is one reason and one reason only why people would want to pass this bill, and that is because lacking other options in pro-choice states, they want to see violent obstruction in front of abortion clinics, which is what we had before the FACE Act was passed, what the FACE Act is designed to stop, what it does stop, and it's all that it does. So we should not countenance the repeal unless we support violence. We should vote against this bill. I yield back.
Gentleman yields back. The gentleman from California is recognized.
Thank you. Mr. Chairman, I've always believed in the right to life, and I've always supported legislation supporting that right. But as I look at this bill, it's not about the right to life or abortion. It's about whether any person has the right to obstruct another in their right to move freely, go about their business peacefully, and worship openly. I agree completely that the Biden administration weaponized this act to single out one side, those opposing abortions, while ignoring the other, those supporting them. The abuse of this act was egregious. It was a direct attack on the right of abortion opponents to peacefully assemble and to express their views. I have no doubts of that. The FACE Act, though, doesn't affect the question of abortion. Rather, it protects every person, pro-life or pro-abortion, in their right to peacefully assemble and to express their views openly. The fact that it was abused was the fault of the Biden administration and not the fundamentals of the law itself. Now, when this bill was drafted, great pains were taken to keep its enforcement balanced. Obviously, our recent experience is that those provisions were not enough. But rather than repeal it, I'd prefer to see that we use this experience to revise it to assure that its administration is even-handed in the future, regardless of who's in power. Perhaps it could include a cause for action for the abuse of this law, or add clarity that it applies solely to physical obstruction of an individual seeking access to any facility, whether it be a church or a pregnancy center or an abortion mill. I agree that the law itself is viewpoint neutral. It was intended to be, but it wasn't used that way by the Biden administration. That's a legitimate concern for anybody who's pro-life. But if I were pro-abortion, I'd be just as concerned that in the future it could be selectively used against them.
Would the gentleman yield for
But rather than repeal it or leave it intact, I think they too should seek to tighten its provisions so that it can't be used against either side, as was the intent of the Congress when it was adopted. Now, I don't have a proposal to bring to the committee today, but if this bill passes the committee, I think that both sides would be well advised to agree to provisions that prevent abuses of this act on behalf of either side. But more to the point, I am watching the lawless and violent mobs that California authorities have allowed to run amok on the streets of Los Angeles in recent days. I believe that the FACE Act is potentially an important law to protect the pro-life minority in California, of which I am one, against violence, intimidation, and destruction if and when the increasingly violent left turns its wrath upon us. With that, I yield back.
Mr. Chairman, would the gentleman yield for a question?
Sure.
Gentleman,
Yeah.
Clintock's time, he yields to the gentleman from New York.
Did he yield for a
He
question?
did.
Yeah.
Thank you. So I take it from what you said, am I correct in taking it from what you said that you oppose this bill, support the FACE Act, and would bring some other bill to our attention?
Would bring amendment to the FACE Act that tightens it up so that it
You
cannot be
oppose this
used
bill to
in
repeal
the
the FACE
future.
Act, would bring amendments?
What's that?
So you oppose this bill to repeal the FACE Act and instead will bring amendments
Yes.
to the FACE Act?
I'm so happy to see that the gentleman's finally listened to me.
I'm glad to hear you oppose this bill. I yield back.
Gentleman yields back. Gentleman from California is recognized. Oh, gentleman from Georgia, I'm sorry.
Thank you, Mr. Chairman. I rise in strong opposition to this bill. We've just sat through this morning the withdrawal of protection to the public from corporate fraudsters and polluters and other miscreants. And now we're doing something, or this committee is doing something far more onerous, far more ominous, far more disturbing, far more frightening, and that is to withdraw protection for reproductive health care providers and their patients. The Freedom of Access to Clinic Entrances Act of 1994, the FACE Act, was passed with bipartisan support in response to escalating violence and intimidation directed against reproductive health care providers and patients. Shortly before its passage, one abortion provider was murdered outside an abortion clinic, and another abortion provider was shot and wounded. Abortion facilities across the country were the targets of arson, bombings, and chemical attacks. As an anti-abortion activist told the Washington Post, the goal of those terroristic actions was to make it so that no doctor was willing to conduct abortions even if they had a legal right to perform them. Clinics were forced to close, and women were deprived of needed health services beyond just abortions. That's why passing the FACE Act was so vital to protect women and healthcare providers. Now, with the overturning of Roe versus Wade, anti-abortion extremists have become emboldened, and we have seen a spike in major incidents against abortion providers, including arsons, burglaries, and death threats. Extremists are traveling or moving to states where abortion remains legal. In 2023, 2024, there were 296 death threats or threats of harm aimed at abortion providers and patients, and 777 incidents of obstruction of abortion clinics, exacerbating the potential for violence. President Trump pardoned almost 24 people convicted of FACE Act violations, some of whom said that they plan to resume those same activities, and they've started recruiting others to join them. Women have the right to make decisions about their own bodies, and that includes decisions about their reproductive health care. Every time abortion rights are up for a vote on a state ballot, most voters want them to be legal. I will fight like hell to make sure that they have that right, and I will not allow it to be undermined by extremists. And it's so ironic that as we debate this very dangerous bill, that with the tax cut that has already been passed by this House, which is paid for by cuts to Medicaid, Medicare, and SNAP benefits, food stamps, that these Republicans want to deprive women of the right to have freedom for their reproduction, while at the same time denying them health care for their pregnancies and denying those babies that they produce food. They don't care about humans. It's a political issue for them, and they have stoked it and worn it out. And let's not continue to play politics with women's reproductive health and with women's freedom. And I appreciate the ladies from Planned Parenthood who are here today. You've shown up en masse. You have your sweatshirts on and T-shirts on, and we appreciate your support. And we support you. And with that, I yield back.
Gentleman yields back. Gentleman from New Jersey is recognized.
Mr. Chairman, I have a unanimous consent request.
Gentleman, pause for a second. Unanimous consent from the gentleman from New York.
Mr. Chairman, I ask unanimous consent to enter into the record a statement on the FACE Act from Judith Applebaum, counsel to Senator Edward Kennedy, Chief Senate sponsor of the FACE Act.
Without objection. Gentleman from New Jersey is recognized.
I thank you, Chairman. So I always like to say it's tell the truth time. And regardless of how you feel about this issue, pro-life, pro-choice, the FACE Act was not enforced properly. And the fact that it could be misused, and I've met some of the people it was misused against, young women who feel strongly, and it is their right to feel strongly, they're pro-life. Prayerful, kind, nice women that were mistreated because they had a different opinion and did protest. You all that are here from Planned Parenthood, and that's a good thing. You're exercising your right, your First Amendment right to be here and to state, as you have it right in front of your T-shirts, how you believe. But what has happened here is if you have a different opinion, which is not the way America's supposed to work, then you're going to be hurt. There's going to be a much stricter level enforcement against you, and it's not even enforcement, it's worse than enforcement. So the stories they've told are true. The old woman that was almost 90 years old could have gently been just somebody, a police officer could have taken her hand and gently moved her away if she was blocking a doorway. This is an old lady. Instead, she was put in jail for years. Come on. Nobody thinks that's right. Nobody thinks that can be good. And it's interesting, if you read the stories, there are many of these stories. It just isn't one incident and one story. The truth is the act is faulty because it allowed this kind of enforcement, unequal application under the law. It allowed the law to be misused for a political force. It allowed people that really disagreed with what was happening in an abortion clinic and wanted to protest, and they do come in. By the way, somebody said, do they come into the Capitol? Yeah, there are people all over the place. I walk down the hall sometimes, they have people that'll corner you. You can't even move around. They're giving you their opinion. But we try to err on the side of freedom of speech, on that side. And here what we did with the FACE Act is truly misuse the law. And if you were pro-life and you had a pregnancy center, somehow you were not protected. That's the reality. And I could take you to meet some of these young ladies, some of these people that work. And they're not just cranky old people that are there, young women, some of whom had an abortion themselves and feel that we should go about things a different way. It is their right. They also should be protected. They were not protected, and there's been plenty of violence, plenty of problems at the pregnancy centers. And you know, there's nobody here that thinks you should be allowed to bomb any facility. There's nobody here that believes that somebody's free speech should be restricted. There's nobody here that believes that an assault should ever be allowed upon another human being. But there are many people here sitting here today, and I think the sponsor of this bill, who believe that the law should be enforced uniformly and fairly and evenly and without prejudice. And when it is not, and if the law allows it to not be enforced the right way, there shows there are faults with the law. So I don't know. I'm not going to give the answer whether it needs to be amended or appealed, but something's wrong. And you meet those people, you'll find out that something wrong. And we should, and by the way, the fact that it was enforced that way, I know everybody wants to be mad at Donald Trump and wants to be mad at Chip or me or anybody that's sitting up here. The reality is, honestly, you should be mad at President Joe Biden because it was under his administration that it wasn't enforced properly, that it was enforced unevenly and with prejudice. It was wrong, and it was un-American, and now we are where we are. So we don't have a bill to amend here. We have a bill to appeal. Maybe after it's appealed, if it is, then we will move forward and we will be able to do something if it's needed. There are plenty of laws in place, to be honest with you. If you are assaulting somebody, you just can't bomb a building anywhere in any state, regardless of how the issues or how the laws are pertaining to abortion. So we already have laws in place to stop any of these violent acts that everybody's speaking about here. But there's one thing I'm sure of. What's happened in the past was wrong. It was wrong for Americans, and quite frankly, it was wrong whether you were pro-life or pro-choice. It was un-American what was done. And with that, I yield back, Mr. Chairman.
Gentleman yields back. Gentleman from Pennsylvania is recognized.
Thank you. As we've heard, the FACE Act was enacted in 1994 in order to address rising violence against abortion and reproductive health care providers. And ever since its enactment, there has been a concerted attack on the FACE Act, part of a long-time coordinated extreme anti-choice agenda that has been openly seeking to gut reproductive rights and effectively ban abortion care in the United States. You can see references to the FACE Act in the infamous Project 2025 manifesto. So for years, our Republican colleagues have ignored the facts, and they're doing it again today, pushing out a false narrative that the FACE Act, a law that is meant to keep all Americans safe, is being selectively enforced. And we're hearing stories about people being arrested for praying. No, people are not being arrested for praying. People are being arrested for making threats and for blockading the entrance to clinics. And I would seek unanimous consent to introduce into the record an AP article dated June 5th, 2024, so not even recent, but anti-abortion activists convicted for blockading a reproductive health clinic, not for praying there.
Without objection.
Thank you. So there is no evidence that there is selective enforcement here, or that the FACE Act has been weaponized against peaceful protesters. Because to the extent that there's any disparity in FACE Act prosecution, that's a reflection of the facts that anti-abortion extremists have historically engaged in higher incidents of violence than those who've protested the often misleading practices of the so-called pregnancy crisis clinics. Look, we should all be condemning political violence on any front, but in repealing the FACE Act, our Republican colleagues are inviting anti-abortion extremists to use violence and threats and intimidation to block access to abortion care everywhere. This is an invitation that they've shown they're only too willing to accept, particularly in the wake of the president's pardoning of people who have been, in fact, prosecuted for those threats and intimidation and blockading. So all women deserve the freedom to work with their doctors and their families to decide on and access the health care that is right for them without the meddling of politicians or extremists. No one should be denied medical care because of someone else's religious or political beliefs, and everyone deserves the freedom to provide or seek appropriate medical care without threats to their safety. So I obviously oppose this bill and its underlying agenda, and I will yield back.
Wait, will the gentleman
I'm
yield?
sorry, I would yield to the ranking member.
Thank you very kindly, Ms. Scanlon, and your remarks prompted a thought, which is several of our colleagues have described the purpose of the FACE Act as unobjectionable. They've described its meaning as good in terms of protecting public health and safety. Their argument is that there has somehow been discriminatory or selective enforcement of the statute. Now, President Trump pardoned every FACE Act convict from the Biden administration, and some people will be cheering that, and others will think that that was totally inappropriate. But in any event, those people have been pardoned at this point. Now our colleagues come forward and say this law, which they otherwise support and whose allegedly unjustly convicted offenders have been pardoned, should be repealed. Well, that's the exact same situation that the January 6th insurrectionists and rioters are in. They were convicted of things like assaulting a federal officer. They've been pardoned, all of them by President Trump. Would our colleagues now say we should repeal the law against assaulting federal officers because they allege with President Trump that it was somehow misused and they were targeted for political purposes? What about seditious conspiracy against the government? Several of the Proud Boys and the Oath Keepers, including Enrique Tarrio, they were convicted for organizing to overthrow the government. That's what seditious conspiracy is. Now, President Trump felt, he didn't articulate it as well as our colleagues today, but the president felt that somehow it was selective prosecution. It was a political prosecution. He pardoned them. Well, why aren't our colleagues saying we should repeal the law against seditious conspiracy? Why aren't they saying we should repeal the law against assault of federal officers? If it's a crime, it's a crime. No crime should be selectively enforced. We can agree or disagree about whether or not that happened, but I just find it odd that after they've gotten their way by having these people pardoned, that they still want to go ahead and just overturn the law completely. Thank you for yielding.
Gentlelady yields back. Gentleman from Arizona is recognized.
Thank you, Mr. Chairman. So in the wake of the Dobbs decision and the leak regarding the Dobbs decision, there were more than 100 pregnancy care centers and pro-life organizations attacked, vandalized, even bombed. And there were more than 300 churches attacked. And that's pretty stark. Now, so why didn't we see more prosecutions? Now, what we heard today is that, well, wait a second, the 90+% of people who are pro-life that were prosecuted, that's because they're the ones that just get out and protest and cause trouble. But I just gave you a bit of a figure, but I think this is important to reflect upon what then Attorney General Merrick Garland said in March of 2023 when he was testifying to the United States Senate. He said it's quite easy for the DOJ to catch pro-life protesters because they protest in daylight. So that's why that's one of the reasons they were going there. But as Attorney General Garland said, those who are attacking the pregnancy resource centers, which is a hard thing to do, are doing this at night in the dark. That might have some influence on your prosecutorial statistics, is that they're going for what I might generously call the low-hanging fruit, that it's easier to go after them. President Biden's prosecutors almost completely ignored the vandalism and firebombs at the pro-life churches and pregnancy centers. So let's not forget, there was absolutely a gross disparity. During the 4 years that the DOJ did a civil rights study and set this thing forward, they prosecuted only 57 people for crimes against reproductive health centers. Only 57. That's interesting to me. So I think you got to remember significantly what was happening. I think Merrick Garland laid it on the table, and in a very kind of disgusting, cynical manner, saying it's easier to prosecute pro-lifers. That's what he's saying. It's easier to prosecute pro-lifers than people who are firebombing and destroying pregnancy centers and churches that represent pro-life. That's the problem that the FACE Act gives you. And for that reason, I support this underlying bill, and I'll yield to the chairman.
Yeah, I just want to comment on this selective prosecution and selective enforcement of this law. That certainly was the case. Remember what happened. May 2nd, 2022, the Dobbs opinion is leaked. By the way, we still don't know who did that. It'd be kind of nice if we knew who did that, because remember what that resulted in. 40-some different churches and pro-life pregnancy centers were attacked between the day of the leak and the day of the opinion, which was June 20. And so in a 7-week time frame, you got like all these places being, I'll go through the list. Some of them. Activists vandalized the CareNet Pregnancy Center in Frederick, Maryland. Graffiti and everything else all over the pregnancy center. In Portland, Oregon, vandals smashed numerous windows, spray painted graffiti on Southeast Portland Pregnancy Resource Center. On Mother's Day, vandals attempted to break into the Oregon Right to Life office in Kaiser, Oregon, used Molotov cocktails to try to do so. May 13th, activists threatening messages all over the Alpha Pregnancy Center in Reisterstown, Maryland. Reisterstown, I may have pronounced that wrong. I'd go to my colleague on the proper pronunciation. June 2nd, anti-life activists targeted the community pregnancy center in Anchorage, Alaska. Broken glass. It was all over the place. And then also, remember what happened in the interim. Between May 2nd and June 24th, there was an assassination attempt on one of our Chief Justices, on Justice Kavanaugh. So there was all kinds of violence going on. But throughout all this, there were 5 prosecutions by the Biden DOJ. Only 5 of these people attacked. And I just read a couple of the list, and I just focused on the crisis pregnancy centers, not the churches that were attacked. So this is our concern. There has most certainly been the egregious abuse, as Mr. McClintock pointed out. There was selective enforcement. We know that. That is our concern. Now, what does that mean, how we change it? That's a debate we can have. I respect that. But it seems to me, if you're going to have this kind of selective enforcement, this kind of problem with this law, maybe the gentleman from Texas is right. We should repeal it.
Mr. Chairman, I have unanimous consent.
The gentleman can state his request.
Yes. I have 4 articles. One is Biden is abusing the FACE Act to silence his pro-life critics, from Newsweek, from Fox.
Objection.
More than 100 pro-life organizations, churches attacked since Dobbs leaked.
Objection.
Vandalized pregnancy centers cry for justice 1 year after Dobbs leak.
Objection.
And the 4th one is DOJ wins guilty plea for one of few pregnancy center attackers caught while pro-lifers sit in prison.
Without objection.
Mr. Chairman, I have a unanimous consent request.
Okay, we'll go there, and then we'll come down this row.
In response to my colleague's statement that folks on your side of the aisle don't want or advocate for violence, I have an article, Axios, written just a few minutes ago. Mike Johnson says Governor Newsom should be tarred and feathered.
Without objection. Okay. I think we got another, then we'll go to 2 UCs. Okay. Ms. Scanlon.
Thank you. I have a unanimous consent request to enter into the record a statement opposing H.R. 589 from the National Council of Jewish Women.
Without objection.
Another unanimous consent request to enter into the record a statement opposing H.R. 589 from the American Society for Reproductive Medicine.
Without objection.
And a final, I ask unanimous consent to enter into the record a statement opposing H.R. 589 from Resolve, the National Infertility Association.
Without objection. Gentlelady from Vermont is recognized.
Thank you, Mr. Chair. It's, two UCs here. FBI offering $25,000 reward for information in series of attacks against reproductive health services facilities. That's from 2023. And FBI Memphis field office offering $25,000 reward for information in the Hope Clinic for women arson investigation. Again, both in the Biden administration.
Without objection. Gentleman from Florida, did you have a unanimous consent? No. Oh, okay. I thought I saw your hand. The chair now recognizes the gentleman from California, and let the record show, it was Mr. Raskin who said Ms. Jayapal had to wait, not me. So I feel bad that she's left. But the gentleman from the gentleman from California is recognized.
My Republican colleagues do not trust women. That's what this is entirely about. The only people in America who are asking for this legislation to be repealed are terrorists. People who would choose to show up and terrorize women as they make a very personal, intimate decision that nobody else should be a part of. You don't trust women. That's what it comes down to. It's not lost on me that on the other side of this debate, it's mostly old men, wealthy, who are partaking in it. I don't see any women on their side. But they sure want to tell women what to do with their bodies. It's an obsession, a sick obsession. They want to tell them what to do before the child is born, but boy, did they take a walk once that kid comes out. They ain't going to be there for their health care. 40% of moms in America give birth funded by Medicaid. Well, they just knocked 15 million people off of that. Most moms in America worry about whether their kid's going to be safe in their classroom from a mass shooting. They just made it easier for people to buy silencers. They made silencers tax exempt. But they're going to tell us that they're here because they're pro-life. There's nothing pro-life about this legislation. Actually, it's anti-life because it stands with and in alignment for people who would bring harm to women. Do you all ever talk to women? Do you know that this decision about what to do with your own body once you're pregnant is the hardest, most personal decision most women will ever make in their life? And that the overwhelming majority, like 80 to 90% of women who make this decision, do it early in the pregnancy. An overwhelming majority, it's because of a health care issue. And you want to stand with some violent asshole who's going to get in their way as they make this decision? I mean, give me a break. And then one of you had the nerve to say, this is about standing up for peaceful protesters? Your guy just sent the Marines to Los Angeles to confront protesters. You sent the Marines, and by the way, I don't know if you've seen the pictures, they are sleeping in squalor. They are sleeping and living exactly the way you would expect them to sleep if their commander-in-chief called them suckers and losers. These pictures are horrifying. This is not about protecting peaceful protesters. This is about harassing women. They deserve better. Sure, if you think it's the most important thing in your life to go to an abortion center and stand outside and think that you're going to persuade a woman to make a different decision, I guess you have a right to do that. I feel sorry that you think that that's your responsibility, but I guess you have a right to do that. But you don't have a right to obstruct them. You don't have a right to get in their way, and you certainly don't have a right to bring violence upon them. And this is all right on the heels of a 25-year-old man detonating a car bomb outside a fertility clinic in my state last month. This is a green light for more violence against women, making this very personal decision. Guys, it's none of your business. You have no business being a part of that decision, and it's a shame that you're going to stand with the terrorists who want to go and try and influence it. We should be doing more to protect women as they make this decision, not taking away barriers. And we have more men on their side coming to join this debate, still no women. Trust women, my friends. Trust women. They will get it right. And I yield back.
Someone yields back. The chair. Question? The committee will stand in recess. We have votes called on the floor, and we'll come back and resume and have the vote on this legislation. And we have one other bill on the calendar for today. With that, we'll stand in recess. committee will come to order. The gentlelady from Washington is recognized.
Thank you, Mr. Chairman. I appreciated Mr. McClintock's comments earlier, just really making the distinction between a law as it's written and how it is applied, and the need to maybe look at this to see if there's anything we need to do to improve the application of it. But I think we all are here understanding that any law can be weaponized by any administration, and we rely on the executive, the good intentions of the executive, of Congress, and of course of the courts to ultimately determine in individual cases whether a law is being applied fairly. I think it's important in this bill, and I appreciate the sponsor's comments earlier on too, because I think that it is sometimes difficult to be consistent, and I think Mr. Roy is very consistent on a number of issues, even if we disagree. And I appreciate that very much, and I think it's why we've worked together on any number of things. This bill is a bill that prohibits the use of physical force, threats, and intimidation designed to interfere with those who are exercising First Amendment rights of religious freedom at places of religious worship. It is not, as has been said, a bill that distinguishes on speech. It applies to violent conduct, whatever the situation might be, whatever your views might be on being pro-life, pro-choice. That means that no matter which side of the abortion issue that you're on, your speech is protected, but your violent conduct is not. And I think that is the important part of why this bill is so essential and why we shouldn't repeal it. If we want to look at ways to make it better, I'd certainly entertain that. But I think that we should all be able to agree that harassing, intimidating, and bullying patients who seek reproductive care services or information, whatever their belief is on which services should be offered, that harassment, intimidation, bullying, violent behavior is wrong. And so for those of us who do believe that people's personal reproductive choices should be theirs and theirs alone, it has been horrifying to see clinics burned to the ground by arson, to see gunmen murdering abortion providers, and bombings that hurt both property and providers. In November of 2015, 3 people were murdered and 9 injured when Robert Deere opened fire with an assault-style rifle at a Planned Parenthood health center in Colorado. In 2021, a gunman attacked the Planned Parenthood clinic in Knoxville, Tennessee, and later that year, that same clinic was burned to the ground by arsonists. And last month, a fatal car bombing partially destroyed a reproductive center in Palm Springs. The FBI labeled that an act of terror. So it should go without saying that when we're talking about enforcing the FACE Act, we are not talking about peaceful protesters. The FACE Act has kept patients, staff, and providers on both sides of the abortion issue safer in their clinics. And I'll remind my colleagues that just 6 months ago, under a Democratic president, my colleagues in this very same committee held a hearing on the FACE Act and seemed to imply that they wanted more prosecutions under the act, not less. So again, it wasn't about whether the act itself was smart or made sense. It was really about how it was being applied. Since the FACE Act's enactment, violence at anti-abortion clinics has dropped by 30%. But the Dobbs decision did embolden anti-abortion activists to escalate their targeting of providers and clinics. And the point has been made by our ranking member and by others on the committee that just simply looking at the numbers of who's prosecuted is not a good way to determine whether or not the law is being applied fairly, because it depends on how many acts of violence there are. And so just consider that between 2023 and 2024, there were 621 incidents of trespassing, 296 death threats, 28 assaults, 12 bomb threats, and 3 arsons. These were around protesters who were committing violence against abortion clinics and abortion providers. This is still a very real issue that needs to be addressed. And I'm going to speak now as one of the 1 in 4 women in America who's had an abortion. I am very grateful that the FACE Act was in law when I had my abortion. These are not easy decisions. They're incredibly personal and private. I never had thought I would have to talk about it. In fact, when I did write my op-ed in the New York Times, I actually had not even told my mother. I think we should be very concerned about making sure we keep the protections for everybody to be able to have these decisions be private medical decisions of their own, and I'm grateful for the FACE Act and its protections in that respect. I yield back.
Gentlelady yields back. Gentlelady from Wyoming is recognized.
Yes, I understand that Mr. Swalwell was waiting for me to come in and speak on this bill so that he could.
I don't know who you are,
so that he could
go ahead.
decide how to vote.
Who are you?
And
I
so
don't know who you are.
I will explain
belongs to the gentlelady from Wyoming.
what my position is. The FACE Act very simply has been weaponized against the pro-life community and ignored when real terrorism is carried out. It has become just one more tool in the anti-life, anti-humanist, anti-American toolkit based on forgiving the unforgivable and criminalizing our reverence for life. It has been broken, and the Democrats, the radical leftists, prosecutors and judges and bureaucrats are the ones who broke it. We now recognize that while the original intent of this law may have been good, the implementation, especially under the Biden administration, has been ugly and unconstitutional. And it has now been turned into a cudgel to destroy the pro-life community. As a result, it's time for it to go, and I support the FACE Act. And with that, I yield the remainder of my time to Mr. Roy.
Appreciate my friend from Wyoming, and I certainly know who she is. She's a fantastic lady and fantastic representative from the great state of Wyoming. And she is one of the many women members of Congress who are co-sponsors of this legislation and women who have written in support of this legislation, because there are many people in this country who believe this legislation is critically important so that you can end the abuse of the existing federal statute to be used politically to target American citizens for political purposes, as was evidenced repeatedly over and over and over again under the previous administration. The fact is, when we're talking about that difference of application, if you look at the data since the enactment of the FACE Act since 1994, if you look at the uptick in attacks on churches, for example, an 800% increase in violence against churches. Since 2018, an average of 39 attacks every month. There have been 96 violent attacks on pregnancy resource centers since the Dobbs opinion was leaked in May of 2022, as the chairman of the committee observed in some data that he put forward. The fact of the matter is it was politicized. But look, we're not going to agree on this, okay? And there's even some colleagues on this side of the aisle who seem to be not bothered by this reality. My concern is that we have too many damned laws. These laws, these issues that we're dealing with right now are all capable of being dealt with at the state level. We either believe in that or we don't. And we can either stick to the premise that we recognize these statutes and these laws exist in every state and every jurisdiction of the country. Murder laws. And by the way, to the extent that I appreciate the comments from the gentlelady from Washington about some consistency, and look, and nothing's 100% black and white. You have to figure out these issues. But, arguing with the Fraternal Order Police and some of my friends in that community about whether we should have a statute essentially federalizing a statute against cop killers and making sure that they're punished accordingly. Well, I despise cop killers. But at some point I have to say, well, at what point and when is this a federal issue? And why should it be? And I understand this. You can say, well, there's constitutional rights at play here from the perspective of my colleagues on the other side of the aisle. Obviously, this is a hotly debated topic about our views on all of that. My friend from California just talked about being able to freely go in and out of engaging. But we don't need a federal statute to talk about freely going in and out of some place of business. We don't need that. I mean, the fact of the matter is there's plenty of state statutes that defend that ability to move around freely in the United States. And if I need the federal government to defend my ability to move around freely, well, God help us all. So forgive me if I don't think this statute is necessary, nor the countless others that I think we will be able to uncover through the Count the Crimes Act, of the numerous federal laws that have been written and put into place because busybody members of Congress feel like they've got another damn issue they got to go solve by introducing yet another law to tell me how to live and tell me what to do and how they're going to give power to bureaucrats at the FBI and law enforcement authorities to come after me or to come after law-abiding citizens. And the fact is, you say, well, okay, they weren't engaging in just prayer. Well, some of them were. Some of them were engaging in protest, no doubt. But I really look forward to all of the venom being issued towards the people that are destroying the city of Los Angeles as we speak, when we had at least one sentence of over 5 years for one of these individuals protesting at an abortion clinic. I yield back.
Gentleman yields back. Question is on.
No.
Oh, I'm sorry. Gentlelady from Vermont. Oh, I'm sorry. Gentleman from Illinois is recognized.
Mr. Chairman, I move to strike the last word.
Gentleman is recognized.
Thank you. We're considering this legislation for one reason: to greenlight violence against abortion care in this country. As my colleagues have said, there's a reason why the FACE Act was first enacted. After the Supreme Court recognized a constitutional right to abortion care in Roe v. Wade, the anti-abortion movement embraced violence and terror as tactics to end abortion access nationwide. These right-wing extremists killed and assaulted doctors. They bombed and set fire to clinics and stalked and harassed patients. After the tragic murder of Dr. David Gunn in March of 1993, Congress decided and enacted the FACE Act with bipartisan support. And after it did, incidents of murder, attempted murder, bombing, and arson targeting abortion care locations all decreased. But these threats are not gone. Violence and intimidation are still a part of the anti-abortion movement in this country. After the fall of Roe, there were huge increases in stalking, burglary, and anthrax and bioterrorism threats targeting abortion clinic staff, patients, and providers. My home state of Illinois is not immune to these tactics. Anti-abortion activists have threatened to slaughter and murder doctors and patients at an abortion clinic in Chicago and firebombed a Planned Parenthood clinic in Peoria. So despite all the rhetoric, the reason the FACE Act exists is because anti-abortion extremists refuse to renounce violence and intimidation to forcibly enact their unpopular agenda. That's why Democratic and Republican presidents alike have enforced the law, including President Trump in his first administration. It's also why federal appeals courts that consider the statute found it to be constitutional. And as we know, the FACE Act doesn't just protect abortion care providers, it protects anti-abortion pregnancy counseling centers and other anti-abortion reproductive health facilities. Those facilities should also not be subject to violence and intimidation, and those who engage in it should be held accountable across the board. But the fundamental problem here is not the FACE Act. It's the reason the FACE Act exists, because parts of the anti-abortion movement embraces violence to achieve its political ends. That's why we need this important law, and it's why I'm proud to have joined a letter earlier this year led by Congressman Nadler affirming our support for the FACE Act and its equitable enforcement. Because the reality is that Republicans talk about crime and then feel violence in our communities, whether it's an anti-abortion violence, gun violence, immigration enforcement violence, or anti-protest violence, the right-wing playbook in violence and domination. I stand against it and yield back.
Gentleman yields back. Gentlelady from California is recognized.
Thank you, Mr. Chair. And I love this. A colleague from the other side of the aisle said, if I need the federal government to tell me how to move around freely, then God help us. Then I would just ask him to call the president and ask the president to get the Marines out of my city, because chaos only ensued when this president was looking for a spectacle to distract this country from the rescission package that we should be talking about that is essentially going to kill Elmo, and among a number of other things, this divorce without a prenup from Elon Musk, and $880 billion in Medicaid cuts. So I am tired of that. I am also tired about the duplicity around this bill. And I love that folks keep saying that they support this legislation and then start talking about the FACE Act. That's how you know that this issue, once again, is being politicized. The issue isn't the FACE Act. And what does this do? It prohibits the use or attempted use of force, threats of force, or physical obstruction intended to injure, intimidate, or interfere with the obtaining or provision of reproductive health services or religious free exercise at a place of worship. It also prohibits a person from intentionally damaging or destroying a facility. So I am gobsmacked, once again, that we have people in this body who are essentially saying it is okay to harm, to hurt, maybe even to kill someone because of a view. Because where were you on January 6th when all this stuff was going down? And it's not about little old ladies. And by the way, little old ladies can be dangerous too, but it's not about little old ladies praying. At best, trespassing crimes. We're talking about murder, attempted murder, bombing, arson, death threats, invasion, blockades, anthrax, bioterrorism threats, assault and battery, kidnapping, stalking, vandalism, and yes, trespassing. We are saying don't do this. And if you want to repeal this act, then you're saying, oh, I condone all of this. I work with abortion advocates. And earlier this week, I got a call about a woman who was trying to get an abortion because she was being brutally assaulted and beaten and had been raped by her partner, was living in a domestic shelter, went to the clinic to get services, was turned away. And she was found by the partner and beaten again and put in the hospital. Wasn't even well enough to get back to the shelter. And essentially, if you want to repeal this, then you're saying it's okay for that to happen to her. And you know what? It's also okay if there are protesters outside the clinic waiting to assault her for trying to handle her medical business. And you cannot be a Christian and condone that kind of activity. And I get those calls on the regular because of the work that I do in my district. And it's not about repealing the act. If you don't like the fact that it's being enforced inconsistently, have that discussion. But hey, wait a minute. Your raptors in the Department of Justice said that they're reiterating the commitment to using the FACE Act to protect fake clinics, okay? Otherwise known as crisis pregnancy centers. And they are going to refuse to do the same for clinics that provide abortion care. So you want to make it like we're having an agnostic conversation about safety. But you have people in DOJ right now saying that they are going to continue to politicize this issue to help one side over the other. I thought at the end of the day, we're trying to keep people safe, regardless of your stance on abortion. So this is a hot mess that we have to even be here talking about this. And I do oppose this bill, and I yield back.
The gentlelady yields back. The gentlelady from Vermont is recognized.
Thank you, Mr. Chair. Donald Trump's plan to kill the national right to abortion essentially worked. 13 states have complete bans on abortion now. Anti-abortion activists are emboldened. Extremists are continuing to harass and intimidate people at their doctor's offices simply for seeking medical care. And now Republicans want to repeal the one law we have to protect access to reproductive health care. Now, the majority's view is clear. We've been here for hours. They want to eliminate the FACE Act, the law that protects reproductive health care clinics and patients from violent threats and attacks. In other words, they don't want to protect Americans at their doctor's offices. The FACE Act is still so relevant. In fact, it's more important than ever. The American people need strong enforcement of the FACE Act in the face of continued and escalating violence, threats, and intimidation against women and their doctors post-Dobbs. According to the most recent report issued by the National Abortion Federation, anti-abortion extremists have now shifted their efforts to block access to healthcare facilities in those states that protect the right to obtain an abortion. Obstruction of clinic entrances in states where abortion is legal increased by over 500% from 2021 to 2022. The pattern is the same when we look at assault, when we look at stalking and bomb threats against abortion providers. In 2023 and 2024, even with the FACE Act in place, there were nearly 1,400 reported incidents of obstructing or trespassing at clinics that provide abortions. Losing FACE Act protections would no doubt put healthcare professionals, their staff, and patients that the law currently protects in more danger from extremist terror attacks. We need to enforce the laws that protect our access to abortion, not repeal them. The FACE Act protects access to reproductive health care and places of worship. The law was enacted because doctors were murdered by anti-abortion religious extremists. That is the hard, cold truth of it. That's why we needed it in the first place. Nurses were assaulted. Security guards were killed. Arson and bombings were commonplace. It's been well documented. And I fear if we repeal this, we are headed right back to that state of violence and lawlessness. I absolutely oppose this bill and urge my colleagues to do the same. At this incredibly dangerous time, we cannot repeal the law that Congress put into place to protect patients from violence. It's unconscionable. And I see that the member, would you like me to yield time to you?
Yes.
Okay.
Only when you're finished, because you're doing a great job.
Yeah, I yield to the member.
Thank you very much, Representative Ballot. You know, we've been talking about the right to reproductive health care, and I used my 5 minutes focusing on that. But while I've been listening to my colleagues and reflecting on the FACE Act, I also started to think about the calls that I made last week and yesterday to the rabbis and members of the Jewish community in my district. And one of the things that I reiterated to them was that once again, I had written a letter to the appropriations chairs asking for additional security assistance given the anti-Semitic acts and violence that had occurred in Colorado and here in Washington, D.C. And unfortunately, when I do go visit the synagogues in my district, I have 5. 2 of them have armed guards in front of the synagogues. And it just occurred to me as we were having this conversation that I didn't tell them that the Judiciary Committee was going to try to take away the ability to prosecute somebody who might want to come in and injure them. But that is exactly what the Republicans, save Mr. McClintock, are looking to do today. So if this bill comes out of committee, I will make sure that I will call all of them back and report that the Republicans on the Judiciary Committee no longer care about enforcing federal law when it comes to our synagogues. Thank you, and I yield back.
I yield back.
Gentlelady yields back. Unanimous consent? Yes, gentleman's recognized.
Chairman, I seek unanimous consent to enter into the record an in memoriam page from the National Abortion Federation noting that there have been 11 murders due to anti-abortion violence.
Objection. Gentleman from Maryland's recognized.
Thank you, Mr. Chair. And
Member, excuse me.
it's a UC to enter in the record a statement opposing HR 589 from Renee Chillian, the founder and the CEO of Northland Family Planning Centers in Michigan.
Without objection. The question occurs on the adoption of the amendment in the nature of a substitute. This will be followed immediately by a vote on reporting the bill. All those in favor say aye. Aye. Those opposed, no.
No.
In the opinion of the chair, the ayes have it, and the amendment in the nature of a substitute is adopted. The question is on favorably reporting the bill as amended. All those in favor say aye.
Aye.
Those opposed, no. The ayes have it, and the bill is ordered to be.
I could request the.
I thought you might do
That'd be great.
that. The clerk will call the roll.
Mr. Jordan?
Yes.
Mr. Jordan votes yes. Mr. Issa? Mr. Biggs? Mr. McClintock? Mr. Tiffany? Mr. Massey? Mr. Massey votes yes. Mr. Roy? Mr. Roy votes aye. Mr. Fitzgerald? Mr. Klein? Mr. Klein votes aye. Mr. Gooden? Mr. Van Drew? Mr. Van Drew votes yes. Mr. Nels? Mr. Moore? Mr. Kiley? Ms. Hageman? Ms. Hageman votes yes. Ms. Lee? Mr. Hunt? Mr. Fry? Mr. Grothman? Mr. Knott? Mr. Knott votes aye. Mr. Harris? Mr. Harris votes aye. Mr. Onder? Mr. Onder votes aye. Mr. Schmidt? Mr. Gill? Mr. Gill votes yes. Mr. Baumgartner? Mr. Raskin?
No.
Mr. Raskin votes no. Mr. Nadler? No. Mr. Nadler votes no. Ms. Lofgren? Ms. Lofgren votes no. Mr. Cohen? Mr. Johnson? Mr. Johnson votes no. Mr. Swalwell? Mr. Swalwell votes no. Mr. Liu? Ms. Jayapal? Ms. Jayapal votes no. Mr. Correa? Ms. Scanlon? Mr. Neguse? Ms. McBath? Ms. Ross?
No.
Ms. Ross votes no. Ms. Ballant?
No.
Ms. Ballant votes no. Mr. Garcia? No. Mr. Garcia votes no. Ms. Kamlager-Dove? No. Ms. Kamlager-Dove votes no. Mr. Moskowitz? Mr. Goldman? Ms. Crockett?
Mr. Issa.
Mr. Issa votes yes.
Mr. Baumgartner.
Mr. Baumgartner? Yes. Mr. Baumgartner votes yes.
Mr. Biggs.
Mr. Biggs votes yes.
Clerk will report.
Mr. Chairman, there are 13 ayes and 10 noes.
The ayes have it, and the bill is ordered to be reported favorably to the House. Members will have 2 days to submit views. Without objection, the bill will be reported as a single amendment in the nature of substitute incorporating all adopted amendments, and staff is authorized to make technical and conforming changes. The committee will stand in recess subject to the call of the chair. Committee will come to order. Pursuant to notice, I call up H.R. 3492, the Protect Children's Innocent Act of 2025 for purpose of markup, and move that the committee report in favor to the House. The clerk will report the bill.
H.R. 34.
Without objection, the bill will be considered as read and open for amendment at any point. The chair now recognizes the gentlelady from Wyoming, Ms. Hageman, for an opening statement.
Thank you, Mr. Chairman. I speak in favor of H.R. 3492, the Protect Children's Innocence Act. Mr. Chairman, today we are facing one of the greatest crises of our time, child abuse disguised as medical intervention. Life-altering gender transition procedures without a full understanding of the meaning or impact. Democrats have embraced an extreme position on gender and the biological differences between boys and girls and men and women. They are clearly more interested in promoting radical leftist policies than protecting children from harm. The radical left has deliberately distorted the public debate surrounding what they refer to as gender-affirming care, which is really nothing of the sort. Instead of accurately describing the procedures as harmful, life-altering, and barbaric, which they are, the left deceptively frames the procedures as being necessary to improve the health and well-being of children. By advocating for these procedures and this level of medical intervention, Democrats are indoctrinating children and encouraging them to make life-altering decisions about their body involving hormones and surgery, jeopardizing their health. Let's call this for what it is. So-called gender-affirming care is the genital mutilation and chemical castration of children. It is not life-saving care, it is child abuse. All evidence points to the fact that these barbaric procedures, including puberty blockers, hormones, and surgeries, are a form of genital mutilation. More and more individuals who were convinced to go down this road are now coming forward to share their horrific experiences of being used as experiments of the medical establishment. The majority of these brave individuals are girls and women. The first rule of medicine is do no harm, yet those in the medical community performing these grotesque procedures on children are committing serious harm. Thankfully, doctors across the United States and in other countries are also beginning to take a stand against those in the medical community who insist that these are, quote, life-saving procedures and should not be questioned. Thankfully, my friend and colleague, Representative Marjorie Taylor Greene, stepped up and introduced the Protect Children's Innocent Act. I thank Representative Greene for her important work on this legislation and for her tireless efforts to protect our children from this evil. The Protect Children's Innocence Act will hold those accountable who perform or attempt to perform genital mutilation or chemical castration on children. The bill expands covered offenses to include the bodily mutilation and the chemical castration of a minor. Victims are protected by ensuring that they cannot be arrested or prosecuted if one of these or other prohibited procedures are performed on them. This issue is really quite simple. Do not force children into making decisions they will not be able to reverse. Do not make these children lifelong patients dependent on the medical system. A civilized society protects its children first, and that is what this bill does. In short, do not abuse our nation's children. I urge my colleagues to support this legislation, and I yield back.
Gentlelady yields back. The gentleman from Maryland is recognized.
Thank you very much, Mr. Chairman. We know that one of the basic tactics in every authoritarian's playbook is to pick out a small minority group in society and scapegoat them, castigate them, demonize them, deny them basic rights and freedoms, dehumanize them, deny their very existence. Jews and Gypsies in Nazi Germany, Christians in Pakistan today, African Americans in Jim Crow America, gay people in Putin's Russia, Uyghurs and Tibetans in China. Just pick out a minority and mobilize the society against them, and you won't have to answer tough questions about your own authoritarianism, your own corruption. Mr. Chairman, I had a very disturbing meeting at the beginning of this Congress with parents of transgender kids who came to see me from my district. And I was prepared for them to be lobbying me on this or that, and I began to talk about different legislation, and they said, no, we know that you're with us on the legislation. We're here to ask you how far you think this campaign is going to go, because a lot of families have started to leave the country and are talking about leaving the country, going to Spain or Portugal or France, somewhere where their families can feel safe. And so I was so taken aback by the conversation and their true alarm and what they're reporting about their kids that I have followed this issue very closely since the new administration started. And indeed, the campaign of demonization and vilification and scapegoating began on the very first day in office. President Trump issued an executive order denying the very existence of transgender Americans. That's an order that George Orwell would have recognized well. He purged government websites of any reference to transgender Americans, just disappearing them. He issued an executive order directing that Americans serving honorably in the armed forces for years or decades be summarily kicked out for being transgender. That's right, a guy who avoided military service himself because of his serious problem with bone spurs and who told Howard Stern that his Vietnam was trying to avoid sexually transmitted diseases at the discos and clubs of Manhattan, is now kicking out of the military thousands of honorable, patriotic Americans, more than 1,000 at least, who've already been kicked out, people who have faithfully and bravely served their country because of Donald Trump's intent and determination to scapegoat these people. He's threatened to defund schools just for supporting trans students. He's trying to bully schools into banning trans girls from playing sports with other girls. And understand what the Biden policy was. The Biden policy was to leave it to the school districts. No categorical ban on transgender kids across the country, across different school districts, but it's up to each elementary school, middle school, high school to work out those issues for themselves. Trump's ordered transgender women incarcerated in women's facilities to be immediately transferred out and placed in male facilities, putting their bodily safety into jeopardy. Today, during Pride Month, no less, which is not to imply that our colleagues are necessarily celebrating Pride Month, but our colleagues go one step further now in this cruel campaign. They seek to deny transgender youth access to potentially life-saving health care, access to the treatments and medications prescribed to them by their physicians in accordance with the wishes of their family, their parents. And they do this while they try to pass the big, beautiful bill that will cut health care to more than 14 million Americans. For the life of me, I don't understand how a party which prides itself so much on the individual's right to make his or her own decisions, the family's right to make the decisions for their own kids, so much so that they would reject the obligation of anybody to get a vaccine in the country at this point for any purpose. I understand it's a principled position. Now you want to say that you're going to make a decision for a family and their kids about how they're to be raised and what health care they need? Big Brother loves their children more than they do? Is that what you're telling us? I mean, give me a break. The so-called Protect Children's Innocence Act, introduced by that famous advocate of public health and children's safety, Marjorie Taylor Greene, would make it a crime for doctors just to care for their transgender patients in accordance with the wishes of their families. All major medical associations in America agree evidence-based gender-affirming care is necessary and in many instances life-saving for transgender youth. And while my colleagues across the aisle today will likely tell you there are young people across the country being mutilated by evil, malicious doctors, that is not the real story. Like all medical care, gender-affirming care is tailored to the age and the unique needs of individual patients in consultation with the families, medical doctors, mental health professionals. And I'm sorry, I trust them more than I trust Marjorie Taylor Greene, who has shown nothing but a spectacular disrespect for scientific professionalism and expertise in the United States of America. Let's not turn the Congress of the United States into a supreme medical board for the country that will override not only the states and the localities and the medical associations and the physicians, but even the wishes of the parents. I wish one of my colleagues would explain that to me, how you expect Big Brother to make better decisions than the families of the kids involved in this situation. It is to elevate your ideological dogma over the needs of real people. Let's stop attacking transgender kids. Let's instead fight to support the programs all of us need. My colleagues voted for a bill that threatens health care for over 37 million children who rely on Medicaid and CHIPS, the Children's Health Insurance Program. They supported cutting benefits for nearly 15 million children who rely on SNAP benefits to get adequate nutrition in America. They want to gut the Department of Education, which ensures nearly 26 million low-income students and 7.5 million students with disabilities will have access to meaningful educational opportunities. If we want to talk about children in America, let's talk about children in America. Let's not demonize and scapegoat less than 0.5% of the population. Somewhere around 1 million people in America are transgender. So let's not pounce on them and demonize them and vilify them and the people who love them and who are trying to take care of them. This so-called Protecting Children's Innocence Act from Marjorie Taylor Greene is the latest effort to attack, demean, scapegoat transgender Americans. I won't stand for it. I urge all of our colleagues to oppose this, and I yield back.
Without objection, all other opening statements will be included in the record. The chair now recognizes the gentlelady from Wyoming to offer an amendment in the nature of a substitute.
Mr. Chairman, I have an amendment at the desk.
The clerk will report the amendment.
Amendment in the nature of a substitute.
Without objection, the amendment in the nature of a substitute will be considered as read and shall be considered base text for the purpose of amendment. The chair now recognizes the gentlelady from Wyoming to explain the amendment.
Thank you, Mr. Chair. This amendment clarifies the definition in the health of the minor section of the bill, and it also clarifies that necessary medical procedures are not defined as mutilation. I urge support for my amendment, and I yield back.
I thank the gentlelady from Wyoming. Who seeks recognition? The gentleman from New York.
Thank you, Mr. Chairman. Move to strike the last word.
Gentleman's recognized.
Thank you, Mr. Chairman. Mr. Chairman, this bill is a disgrace in a long line of disgraces. It outlaws gender-affirming care. Gender-affirming care we know to be life-saving procedures. The suicide rate of transgender teenagers who are denied this care is sky high. We started out with the president's executive order denying the existence of transgender people. They don't exist, but they obviously exist enough to be kicked out of the military, not categorized in male. Now, if you say there are only two sexes, males and females, then the males in the military who are transgender should have been declared males and kept in the military. Instead, we kick them out. That doesn't make sense. It's just an exercise in prejudice. And who are we to dictate to families and doctors as to the proper medical care for their teenagers? We know that the suicide rate of trans teenagers who don't get gender-affirming care is very high. It is and this bill would make it a crime to properly treat transgender people. The medical societies recognize that transgender is a category. We know that there are not just two sexes, male and female. For decades, it was criminal to be gay, to be homosexual, to be lesbian. And people were subject to blackmail for that. Just watch The Manchurian Candidate, good movie. We know better than that now. So why don't we know better than that about transgender people too? We have to open our eyes and see what's in front of us. Enabling families, troubled families, to go to their doctor and say what's wrong. And the diagnosis is that this kid is trans and needs gender-affirming care. If they decide to do it, who are we to tell them not to? Are we a dictatorship? We dictate to families? That's what this bill would do. This bill is a disgrace. It is Big Brother. The Republican Party supposedly is the party of small government. And here it is saying that Big Brother knows better than the family, the family doctor. That is not right, and we shouldn't pass this bill. And I'll yield to the Mr. Raskin.
And I thank the distinguished gentleman from New York. I wanted to enter for the record a unanimous consent request. This comes from the American Academy of Family Physicians, the American Academy of Pediatrics, the American College of Obstetricians and Gynecologists, the American College of Physicians, the American Osteopathic Association, and American Psychiatric Association, titled Leading Physician Groups Oppose Infringements on Medical Care Patient-Physician Relationship, dated May 1, 2025. And I want to just quote a paragraph. Our organizations have consistently opposed any legislation, regulation, or executive action that interferes in the confidential relationship between a patient and their physician or undermines the provision of evidence-based standards of patient care and physician training and education. Patients must be able to discuss health issues with their trusted physician to determine together what care is best for them. They make a very powerful argument against what Marjorie Taylor Greene wants to do in this bill. And I must say, Mr. Chairman, in requesting UC, I trust the American Academy of Family Physicians, the American Academy of Pediatrics, the American College of OBGYNs, the American College of Physicians, the American Osteopathic Association, American Psychiatric Association, than I would trust, before I would trust Congresswoman Marjorie Taylor Greene.
Without objection,
Reclaiming my time. The gentleman has recited the list of just about every medical society in the United States. And this committee, through this bill, proposes to execute our judgment, a bunch of politicians, over all the medical professionals, over all the societies representing medical professionals in this country. If it weren't for the fact that doing so would hurt many people, would cause many suicides, this would be laughable. Mr. Chairman, I yield back.
Who seeks recognition? The gentlelady from Wyoming.
I can understand why there are some in the medical field that support these kinds of procedures. They're huge moneymaker opportunities. Recently discovered video from 2018 revealed a Vanderbilt University Medical Center doctor touting the pediatric gender-affirming procedures are, quote, huge moneymakers for hospitals, and a staffer saying anyone with a religious objection should quit. The video further featured a doctor hyping the profits hospitals can make from performing medically unnecessary double mastectomies on young girls. Such a vile procedure is widely referred to as top surgery in the contemporary language of transgender ideology. The fact is, a growing number of experts in Europe and elsewhere are proposing that there is limited existing evidence that supports gender-affirming treatments in children with gender dysphoria. For example, the National Health Services of England and the Swedish Agency for Health Technology Assessment and Assessment of Social Services conducted 2 recent systematic reviews to assess the evidence of the effectiveness of hormone therapy, puberty blockers, and gender reassignment surgeries in adolescents with gender dysphoria. The 2021 and 2022 studies determined that, quote, the scientific evidence is insufficient, end quote, to accurately evaluate the effects of these treatments in minors, though both studies concluded that there is some support to suggest that the hormone given to delay puberty, GnRH, may inhibit normal bone development in children. In fact, what we know is that this particular drug carries risks of significant harms, including infertility, sterility, sexual dysfunction, impaired bone density accrual, adverse cognitive impacts, cardiovascular disease and metabolic disorders, psychiatric disorders, surgical complications, and regret. So yes, it makes sense for those in some in the medical field to pursue this because, as they've indicated themselves, as they've admitted, they can make massive amounts of money by undertaking these absolutely brutal type of treatments on minors, no less. And what do I mean by the brutal types of treatments? I'll read some of them to you. It's not just, quote, top surgery that can make the hospitals money. These doctors shockingly boasted about lucrative, quote, bottom surgeries. What an interesting euphemism we have here. And promoted the money to be made on phalloplasties performed on girls. These, quote, bottom surgeries for girls nonsensically claim to help masculinize gender affirmation and involve numerous high-risk procedures, including creating the penis, lengthening the urethra so that a biological female is able to stand to urinate, creating the tip or glands of the penis, creating a scrotum, removing the vagina, uterus, and ovaries, placing erectile and testicular implants, and skin grafting from the donor tissue site. Isn't it nice that they refer to this as, quote, bottom surgery? When I talk about this as being barbaric, I think that's actually an understatement. And I can see that in a couple of years, we're going to look back on this period of time, and we're going to be absolutely horrified that we allowed people to do this to our children, that we allowed them to make these decisions for children so that they could have these kinds of surgeries and medical intervention. So yes, it is not surprising to me that you have some in the medical field that want to continue making money. And the younger the patient that they can bring in, the more money that they can make. Because once you start down this road, you will be a lifetime medical patient, both in terms of the psychiatric care that will be necessary, as well as the pharmaceutical intervention that will be necessary, and the ongoing surgeries that will be necessary, in addition to, as I've indicated, having problems with cardiovascular disease and metabolic disorders. With that, Mr. Roy, I will yield the remainder of my time back to you.
With that, I'll now recognize Ms. Garcia. Okay, Mr. Johnson.
Thank you, Mr. Chairman. I rise in strong opposition to this bill. I strongly oppose this bill because it's an extreme attack on parents, on doctors, on science, on freedom, on liberty. This bill would throw doctors in prison for providing medically necessary care that is supported by every major medical and mental health association in the United States of America, including the American Medical Association, the American Academy of Pediatrics, and the American Psychological Association, among others. And not only that, this bill would throw parents in jail if they help their child access evidence-based treatments from a medical professional. When a child is suffering and needs medical care, I want them to get the treatment that their parents, and their doctor believe is best. There's no space in that exam room for a MAGA Republican politician who wants to deny appropriate medical care from your kid out of either cruelty, ignorance, or both. This bill shows Republicans' hypocrisy. It allows puberty blockers and hormone therapy for cisgender youth, just not for transgender youth. That's because Republicans want to target and demonize trans kids. And that targeting has real consequences because gender-affirming care has been shown to decrease the dramatically high rates of suicide and depression for transgender and gender-diverse youth. We need to be giving kids the tools to thrive, not taking away their health care as a political ploy. I was proud to join an amicus brief in the pending case of United States v. Scrimetti, which highlights the role animosity has played in legislation banning medically necessary care for transgender youth, and urging the Supreme Court to strike down the Tennessee law at issue in the case. Because this bill ignores science, puts young people's lives at risk, and criminalizes doctors for providing appropriate care, I urge my colleagues to oppose this bill, and I yield back.
Gentleman yields back. Is there further discussion? Mr. Orton.
Thank you, Mr. Chairman. Since my first week in Congress, I've been calling for federal action to dismantle the transgender industrial complex. One essential step is defunding sex trade altering treatments on minors. During the Constitution Subcommittee's hearing on Congressman Green's bill, I spoke about the costly sex-altering treatments that are being paid for in some states by the Medicaid program. I led a letter to CMS trying to quantify how much U.S. taxpayers were spending on this grisly activity, but pinning down that number is difficult because of the rampant fraud and abuse in billing and coding for these procedures. For instance, these transgender clinics billing for precocious puberty or hypogonadism, when really they are using those drugs for gender transition. It is essential that we preserve the language in the House passed one big beautiful bill that defunds mutilating and sterilizing sex trait altering treatments in Medicaid. Our Senate colleagues must preserve that language. As medical doctors, we take an oath to do no harm. There is absolutely nothing evidence-based about chemical castration or genital mutilation of children. The Dutch protocol and the WPATH guidelines are garbage. 3 systematic reviews in the UK, the US, and Sweden have refuted and shown the utter scientific nonsense embodied in the Dutch protocol, basically the protocol that's being cited by my Democrat colleagues today. The reconciliation bill reflects the thrust of one of the first bills I introduced when I came into Congress, H.R. 2387, the No Harm Act, along with which contains the defunding of transgender mutilation, as well as conscience protections and a private right of action for those harmed by this grisly industry. Over the past few years, so-called doctors working in pediatric transgender clinics have prescribed medicines or done procedures they know will permanently sterilize children and leave them with irreversible psychological and physical damage. This is done in service of their poisonous gender ideology. They also exploit vulnerable children and young adults, often those suffering from anxiety, depression, autism spectrum disorder, or are victims of domestic violence. They promise these poor young people that their problems will go away and they will be happy if only they embrace gender ideology and undergo gender transition. These so-called doctors do this in service of their sick ideology, and as one of them put it, because the procedures are big money makers. The No Harm Act codifies President Trump's Day One executive order and protects taxpayers from being forced to subsidize the abuse of the vulnerable. Another federal solution, of course, is before us today. This is to hold the quack doctors accountable for performing these horrific treatments on minors. Congressman Green's bill does so by instituting criminal penalties on anyone who performs sex trait altering treatments on minors. This so-called gender-affirming care is clearly child abuse. In 2021, 4,000 Americans aged 6 to 17 began cross-sex hormone treatment for gender dysphoria. Most of those 4,000 children didn't even know at the time they were signing up for a lifetime of fertility issues and other serious health problems. If a child takes puberty blockers before beginning hormone therapy, they will not develop gonadal tissue or gametes, resulting in permanent loss of reproductive capacity. We do not even let children get their ears pierced without better informed consent than this. There is also a long list of side effects in addition to infertility. I'm proud to support the Protect Children's Innocence Act of 2025, and I yield back.
Gentleman yields back. Is there further discussion? Ms. Jaya.
Thank you, Mr. Chairman.
Sorry, Mr. Garcia.
Thank you, Mr. Chairman. I move to strike the last word.
The gentleman is recognized under the 5-minute act. He doesn't need to strike the last word.
Thank you. I join the Democratic colleagues in strongly opposing the criminalization of gender-affirming health care for minors. This bill is a shocking overreach, even for a party that does nothing else except overreach. It ignores science, it endangers young people, and criminalizes doctors for doing their job. The reality is that every major medical and mental health association, as has been shared, in the country supports age-appropriate, gender-affirming care for transgender people. And like other kinds of health care, Congress should not be in the business of dictating medical decisions. And far from protecting young people, this bill only continues the Republican Party's ongoing war against the most vulnerable communities in our country. Criminalizing gender-affirming care will only stigmatize and endanger the lives of young people who should be making sensitive medical decisions in consultation with their medical providers and parents or guardians, not with Marjorie Taylor Greene. But this outcome isn't a coincidence. It's exactly what Republicans want to do. As they have done in states around the country, Republicans pretend to be protecting children when they're just punishing medical providers, caregivers, and the children themselves. Let's take a step back and just think about how absurd it is to be prioritizing a bill like this right now. Trump has tanked the economy, declared a war on immigrants, repeatedly violated the Constitution, and directed Republicans in Congress to destroy Medicaid, food assistance, and Pell Grants, to give hundreds of billions of dollars to ICE and the richest people in the country. Instead of even pretending to defend liberty, freedom, and small government, Republicans are rushing to embrace deportations of U.S. citizen children with cancer, the militarization of our communities, with violent suppression of speech and dissent, and the persecution of the most vulnerable amongst us. And it's only going to work if we allow it to. In this moment of authoritarian overreach, people across the country must stand together in solidarity. We must reject this administration's civil rights violations against people of all backgrounds. We must not fall for the trap and believe that the source of our problems is trans people, immigrants, and young people. Because the real problem is billionaires and politicians who are happy to trample on the Constitution and make a quick buck off of it and the backs of the working class. Let's keep the focus on them and stop them from destroying our country while we still can. Thank you, and I yield back.
Gentleman yields back. Is there further discussion? Ms. Hageman.
Yes, Mr. Chairman, I have an amendment at the desk.
Clerk will report the amendment.
Amendment to the amendment in the nature of a substitute to H.R. 3492, offered by Ms. Hageman of Wyoming. Page 8, line 19.
Without objection, the amendment be considered as read. Gentlelady from Wyoming is ready.
I'll reserve the point of order, Mr. Chairman.
This amendment simply strengthens the definitions of biological sex as well as the definitions of male and female in the legislation, and I urge support for my amendment, and I yield back.
Gentlelady yields back. The question is on the amendment by the gentlelady from Wyoming. Is there further discussion? Is there discussion?
But perhaps the introducer of the amendment could explain what the purpose of the amendment is.
I can. As I said, it strengthens the definition of biological sex, and then also it further defines male and female. As you can see, it would insert these definitions on page 9 after line 18. Identifying male means a person who naturally has, had, will have, or would have, but for a congenital anomaly, historical accident, or intentional or unintentional disruption, the reproductive system that at some point produces, transports, and utilizes sperm for fertilization. For female, the term female means a person who naturally has, had, will have, or would have, but for a congenital anomaly, historical accident, or intentional or unintentional disruption, the reproductive system that at some point produces, transports, and utilizes eggs for fertilization.
Mr. Raskin has the time.
Okay, but I'm no expert in this amendment, and So I'm not quite sure, if the gentlelady would just yield for a quick question, is there some particular scientific provenance for this definition? Is it? Yeah.
That what's funny is if you just read the definition, I think that it is something that we probably all learned in high school biology. For far too long, Democrats have been pushing dangerous gender ideology on children, claiming that you have a sex assigned at birth versus sex that you may identify with. This is leaving children more confused about basic biology and leading them down the path of life-altering decisions.
Okay, reclaiming my time here. If I'm reading the definition correctly, and again, the gentlelady has not clarified where it comes from. I don't know which medical association or scientific group came up with this, but this seems to be perfectly consistent with people being transgender. It says the term male means a person who naturally has, had, will have, or would have, barring congenital anomaly, historical acts. So I don't know. Again, we haven't had any hearing on this, but this doesn't seem to be incompatible with there being transgender people, which obviously there are. There seem to be more than 1 million of them in the country. Right?
This is the definition of male and female included in the bill.
Well, again, is there any scientific basis for this, or did you just offer this one?
Well, it's so obvious that so many times the Democrats are unable to define men and women. And so that's what we've done. We've defined male and female.
All right, well, if you're the expert, you tell us where you got this information.
We've defined it in this bill.
Okay, so in other words, it's a creation of the GOP staff of the Judiciary Committee?
I think that this is a biological definition of male and female.
From where? Yeah, it already says biological.
Right.
Physician would be.
But you're amending a bill which already has the language of the biological definition. It says the term biological sex means the indication of male or female sex by reproductive potential or capacity. Sex chromosomes and naturally occurring sex hormones, gonads, or internal or external genitalia present at birth. Well, I mean, what is your problem with that definition? I'm not necessarily opposed to yours. Yours seems to be much more embracing of the transgender idea than the other one does, but I'm just curious where it comes from if we're going to proceed on the basis of science.
This was what I was provided as far as the amendment for the bill.
All right, well, thank you for that inquiry that you made into it. I think that people's privates should be private. I'm a little embarrassed by a lot of the conversation today, and I think all of this is unnecessary, and all of it is a massive intrusion into the private family life of the patients, states' power to regulate medicine, and the medical associations that have actually worked on this. So I'm not quite sure which of these two definitions is superior to the other. I'd be interested to know whether anybody has any scientific basis for it. I mean, I'm happy to yield to anybody. Perhaps Ms. Valiant could help me out.
Oh, well, a question that I had is that I noticed that what my colleague has brought forward does not acknowledge at all the fact that there are intersex people who are born with sex characteristics that do not fit typical binary notions of male or female. And any doctor who is worth their salt will tell you that that is the reality, that there are intersex people living across this country that do not exactly fit your definition. So I want to know, where do they fit in? Do they not exist?
This bill isn't directed to that. This bill is the mutilation of children.
We're reclaiming my time. Let me reclaim my time.
Allegedly,
Mr.
allegedly
Raskin.
change the gentleman gender.
Mr. Chairman, look, the gentlelady from Vermont makes a very important point, which is there are people who are born with intersex genitalia. And she asked, where does this fit into this definition? Again, nobody has really clarified why this definition is superior to the one that is already in the bill. From my perspective, all of it is a massive invasion of privacy, and I'm just surprised that none of my colleagues has mentioned the word parent or mother or father today. If we're talking about vaccines for children, I think everybody would say that should be up to the parents. Why have the parents completely disappeared from the picture here? Is nobody interested in the parents? I mean, shouldn't we be trusting them to love their children a little bit more than Marjorie Taylor Greene loves them?
Gentleman's time has expired. Is there further discussion, Mr. Onder?
Yes. Will the ranking member yield?
Yes, by all means.
Yeah, I'm not sure. I believe, and I was just handed this definition myself, I believe that this definition covers a couple of things. I think it does cover the issue of intersex individuals who have congenital anomalies. Also, the part about the congenital anomalies could also include genetic abnormalities like Klinefelter syndrome, which is a male with YO chromosomes who are sterile, and of course Turner syndrome, which is XO, which individuals who are also female but sterile. So I believe that's the purpose of this definition.
Mr. Onder, would you yield?
Yes.
For further clarification, this is the definition that was included in Dr. Marshall's Senate File 977 in the bill that he introduced, which was to prohibit taxpayer-funded gender transition procedures and for other purposes.
Does the gentleman yield back?
Could I answer the?
Well, the gentleman, Mr. Onder controls the time. Mr. Onder?
Mr. Onder, will you yield for a question?
Yes, I yield.
Thank you.
Yes, I yield.
So your question's a strong one, and it raises for me, how are we going to interpret and apply these definitions? In other words, let's say a person presents themselves to you, what would you do in order to determine whether they have gone through the congenital anomaly or historical accident or intentional or unintentional disruption and so on to qualify as a male or as a female? In other words, how does this improve upon asking someone, are you male or female? Right, yeah, that's my question.
Well, I think the point is that sex, male or female, is a biological reality. It's not a social construct or a psychological construct. It's not. Sex is sex. There are males and females, and that is
and
what
intersex, which is my
this
point.
law. Well, folks who are intersex or male or female, they have congenital anomalies, but they are.
Will you yield for a question, Mr. Onder?
I will yield.
What time is it? I'm sorry. So, in good faith here, I'm trying to engage with you in a colloquy because I do not understand. So you're saying there are intersex people. They have sex characteristics of both male and female. And the question goes to the heart of who is deciding that? Who is deciding how they are presenting? So you're going to tell.
It's usually decided by genotype most often, and again, there are abnormal genotypes like
No. I'm
like
saying
XXY,
no. If I
Klinefelters,
could, I want to get back to.
Turners.
I'm asking you a serious question here. I'm asking you a serious question.
I'm giving you a serious answer.
Who? But is that person who is presenting with both characteristics? Do they get to decide how they are presenting in the world?
Well,
if
I decide tomorrow that I am a woman, I'm still a man because
I'm talking about intersex
I meet
individuals.
This definition.
I'm talking about intersex individuals. That's what I'm talking about here. Are you deciding for them?
No,
Who's deciding?
There is a biological reality that this definition would recognize.
Well, I disagree, but I appreciate you
If the gentleman would yield for one follow-up on that.
Yes.
So I accept your position that it's a biological reality, although that departs from the language here, which talks about historical accident or intentional or unintentional disruption, which doesn't seem to relate to biological condition.
No, the historical accident would mean, for instance, if someone suffered a tragic accident that rendered them infertile. If that happened to a man, if it happened to me, I would be rendered infertile.
I got you.
I'd still be male.
So my question remains, though, say in the case of an intersex individual or somebody who is born infertile for different reasons, who makes the decision, who applies what you're describing as the biological standard? Who decides that? Is it the person and their family and their doctor, or is it the U.S. Attorney General, the U.S. Attorney for the district?
Well, I think what you're getting at, you're trying to get me to embrace your idea of this term sex assigned at birth, but there is a biological reality that the baby born is male or is female. They may have, this baby may unfortunately have a genetic abnormality like Turner's and be XO genotype or Klinefelter's XXY genotype, or maybe have other testicular feminization, various other birth defects, but that doesn't change the fact that that individual is male or female. And this, I think that's what this definition covers.
Gentlemen's time has expired. Who seeks recognition? Question, it's an amendment, right? The question occurs on the amendment offered by the gentlelady from Wyoming. All those in favor say aye. Aye. Those opposed, no. No. In the opinion of the chair, the ayes have it, and the amendment is adopted. The question now is, who seeks recognition? Gentlelady from North Carolina.
Thank you, Mr. Chairman. And this has been kind of a mind-blowing conversation today, but I just wanted to share something that this bill and so many of the other bills targeting the transgender community, the effect that it has been having on our children. So I had a roundtable to talk about nutrition assistance and small businesses a couple weeks ago in my district, and it was just people sitting around talking about how to get more money for the food bank and for school nutrition and how to support our small businesses. And after we finished the roundtable, a woman came up to me with tears in her eyes and asked if she could talk to me. And I said, of course. And she told me that what is going on in Congress and with our president and the lack of any compassion for people who are transgender has caused her child so much distress that her child is thinking about leaving this country. And her child is transgender. And it feels like ever since this Congress has been in session and this president has been really exploiting that child's entire being, that they're not safe in this country. And then I started to cry. And I hugged her. And I said, I will go back to Washington and share your story. So I'm doing that today. Thank you, and I'll yield back.
Gentlelady yields back. Gentlelady from Washington is recognized.
Mr. Chairman, I have an amendment at the desk.
Clerk will report the amendment. Point of order reserved by the gentleman from Arizona.
Amendment to the amendment in the nature of a substitute.
Amendment will be considered as read. The gentlelady from Washington is recognized to explain the amendment.
Thank you, Mr. Chairman. This has been a bizarre conversation, and it's very difficult to engage with it if you're actually engaged in any kind of reality about what gender-affirming care is and who trans people are. And we've had all kinds of things be said here, words be used. Republicans are bringing yet another despicable bill that attacks the transgender community. And the gentlelady who introduced the bill is calling practices barbaric, but she can't tell us even where the definition she introduced came from. What is barbaric is this legislation. What is barbaric is targeting trans kids in this country who are not doing you any harm. Show me a trans kid who's doing you harm. And then tell me how many of you are parents that would do anything that you could to protect your kids and to make sure that they didn't commit suicide, that they were actually able to engage in the world in a healthy way. Tell me what you wouldn't do for your children. Because when you introduce legislation like this, it is not only stupid legislation, it is cruel, it is mean, and it interferes with your own conservative principles. You really want to take away the ability to allow parents to make decisions about their own kids' medical situation with their doctor? That's what Republicans want to do? Now, I know we're all inconsistent in different ways, and there are people on that side who have been consistent on issues of debt and deficit. Both of us on either side of the aisle have taken up issues of privacy. This is a giant inconsistency in the Republican Party right now. You are supposed to be the party of limited government that doesn't get in the way of parents making decisions for their own kids. Remember parental rights? Remember individual rights? But that's not what you're doing. And don't just take it from me. In 2018, when the anti-trans political attacks were beginning, Barbara Comstock, who is a Virginia Republican who served in Congress, many of us knew her, said, quote, "It opens a Pandora's box when you don't allow the parents and the doctors to make this decision." Who are you to get in the way of a parent making a decision about their own kid's health? And, you know, when you talk about, I wrote some things down as you were talking because this whole thing is ridiculous. You want to talk about the industrial medical complex in healthcare? Well, let's talk about that. Why don't we go after those for-profit private insurance companies that have taken over healthcare and made 1 in 3 Americans have medical debt? You want to talk about irreversible psychological damage, another thing that you over there are trying to say about our kids and what we make decisions about? Well, let's talk about cutting nutrition assistance. You want to cut nutrition assistance, $2 a meal from kids who are hungry. That's what your big bad betrayal bill does. You want to talk about irreversible psychological damage? Let's talk about child abuse. Let's talk about separating moms and dads from their kids, immigrants, locking them up indefinitely. That's what you just put in the bill that we voted through the Judiciary Committee. So what the hell are we doing here, Mr. Chairman? Let's be a little consistent and precise and stop attacking trans kids. That's all this does. Now, I do have an amendment here, but it was all, I just have been listening to this and I cannot believe what this conversation has been about. My amendment would allow medical professionals to continue delivering healthcare to young trans people when it is considered a best practice. It recognizes that this care is safe, widely accepted, appropriate, medically necessary, and most importantly, it allows transgender people to live safely and authentically as themselves. Any parent over there, do you want kids to commit suicide? Is that what you'd like? Do you want them to not get the counseling that they need? Because that's what gender-affirming care is. In very rare cases, there is surgery that is prescribed. But you guys make it sound like this is some giant, terrible thing that parents are doing for their kids. You're parents. Why are you getting in the way? Why are you letting government get in the way of parents making decisions about their own kids with their own doctors? It is absolutely outrageous, and you should, at a minimum, vote for this amendment. And the chairman is always generous with me because we have spoken about this issue. And he knows damn well what it means to be a parent and to protect your child. And I'm gonna do that every frickin' day that I'm here in this committee when you bring up these ridiculous, barbaric bills that target trans kids.
Gentlelady's time has expired. The chair now recognizes the gentlelady from Wyoming.
First of all, we're not claiming kids are doing us harm. We are trying to protect them from harm. And protecting children is not inconsistent with our conservative philosophy. We are not mobilizing against our children. We are mobilizing to protect them. We are not demonizing children. We are trying to protect them from people who seek to use medical intervention to erase the essence of their very being. I want to remind the committee that this bill HR 3492 is actually an amendment to existing law, 18 U.S.C. Code Section 116, which was introduced by Representative Sheila Jackson Lee, and it was entitled Female Genital Mutilation. And the very purpose of it was to prohibit female genital mutilation. It was passed. It was a bipartisan bill that was passed. This is merely an amendment to that bill.
Would the gentlelady yield?
No, I'm not finished yet.
I wanted to ask you if you know what female genital mutilation is.
I am not finished. If you will remember, at the time that this was brought forward in 2020, and even its predecessor in the 1990s, it was because of the issue of young girls, young women who were having, their parents were the ones who were taking them to have the female genital mutilation. So when you talk about this being a parental right to obtain medical intervention for their minor child, the very law, the very statute that we are amending specifically identifies and recognizes the fact that sometimes parents don't have the best interests of their children at heart, and that's why on a bipartisan basis in 2020 there was a law that was passed that made female genital mutilation illegal. So I want to make sure that people understand that that is the very purpose of the bill that we are considering as an amendment to an existing statute. I also want to point out that throughout history we have examples where the medical community has been so blatantly wrong in terms of the advice that they were giving. For example, in the 1930s, recommending that women smoke cigarettes, it will make them feel better while they're pregnant. We have the situation of the radium, recommending the use of radium, lobotomies from the 1930s through the 1950s. The gentleman who invented lobotomies actually received the Nobel Prize in medicine for that. We don't do lobotomies anymore. We recognize how barbaric that procedure is. Hormone replacement therapy without risk disclosures, forced coerced sterilization. We have a history of that. We just went through COVID-19, for goodness sakes. We had Anthony Fauci lying to us every which way from Tuesday about that masks are unnecessary and that we need to have masks and that you have to have the vaccine and the vaccine isn't going to cause any problems. And now we have all of the evidence demonstrating that the vaccines cause incredible medical problems for a certain subset of our population. Yet we were lied to over and over and over and over again just during COVID-19, and it was the medical field that did it. It's why there is such a distrust in the medical field right now. So when you talk about how there are these medical protocols and this is best practices, that's most likely based upon what is the Dutch protocol. The Dutch protocol that has been cited so many times by Democrats has been entirely discounted as being a situation where they actually cooked the books. You want to know how they cooked the books? According to a 2023 study, the premise of the Dutch study is flawed on account of 3 methodological biases that undermine the research. These include 1, dropping subjects from the study who experienced unsuccessful results. Number 2, altering the gender dysphoria scoring mechanism after the treatments were conducted in order to guarantee a significant post-surgical drop in gender dysphoria scores. And number 3, compromising findings of psychological benefits of hormone therapy by conflating the results of several treatments and factors such as gender reassignment therapy and psychological maturation. The results of this Dutch study have never been replicated despite the fact that there have been many efforts to do so. So when you talk about best practices, when you talk about the parents being the ones who get to make this decision and then attack us and make it as though we don't care about children, that we don't care about their well-being, the very purpose of this bill is to protect children from the people who would harm them through this type of medical intervention. With that, I yield back.
The lady yields back. The ranking member is recognized to speak on the amendment.
Thank you kindly. I rise to oppose the amendment. The gentlelady from Wyoming, I'm afraid, makes a series of arguments. Oh, we're still on the Jayapal amendment. I support very strongly the Jayapal amendment, and thank you, the gentlelady, for offering such an eloquent defense of it. But in answer to the criticism from the gentlelady from Wyoming. She makes a series of arguments that completely contradict her own position. She says, for example, that there have been all kinds of changes in our understanding of vaccines, which sounds like it would be an argument against having a national compulsory mandatory vaccine for everybody in the country, which of course we didn't have during COVID-19. But the logic of what she's vaccine, too bad for you. The federal government now has the power to do it and is invited to do it because they're saying that the United States House of Representatives and Marjorie Taylor Greene love your children more than you do. They are going to make decisions in the best interest of your child that you wouldn't make for yourself. We're going to leave it up parents to make medical decisions for their own children on the grounds that you're going to protect the children against the parents, which cuts completely against, I think, everything that you and other Republicans were saying about the vaccines. You didn't want government at any level, much less the federal level, deciding what was best in the best interest of the children. So this leads me to believe this profound, stunning contradiction that you don't really have the best interests of these children at heart. I'm much more drawn to what Ms. Jayapal has suggested in her amendment, which is we operate on the principle that parents are going to be acting in the best interest of the children. In fact, that's the standard in any family courtroom in the country when it comes to an award of custody. What's in the best interest of the children? And it's going to be one parent or the other, except in the most extreme and extraordinary case, right? So now Ms. Jayapal says, let the parents trust the doctors. The families that go through this question go right to the doctors and physicians and the psychiatrists to find out what is the best evidence available about what's going on. And now we take what is undoubtedly an extremely difficult situation, as all family medical situations are, and we compound it with the intrusion of the federal government for totally exploitative partisan purposes. And that is a scandal and an outrage. So let's give the families some room to make their own decisions. Let's let the states regulate medicine taking place within their own communities. Let's let the medical associations advise the state legislatures. And we don't need Big Brother doing this. If we want to help the families of America, let's not throw 15 million people off Medicaid. Let's not be slashing SNAP benefits and cutting child nutrition in the country. And I'll yield the remainder of my time to the offerer of the amendment, the distinguished gentlelady from Washington.
I thank the gentleman for yielding, and I wanted to just have a conversation with you because also, if you noticed, and if we went back and looked at the transcript, the gentlelady from Wyoming actually said, we can't trust parents. In your comments, you said parents make decisions that are wrong for the kids. So I feel like you kind of answered the question for me about whether or not we should trust parents. And all of a sudden, the Republican Party, that was the party of saying limited government, we don't want you telling us what to do as parents, all of a sudden now you are saying that you don't trust the parents. It's clear to me that you don't trust the medical establishment, even though every major medical organization, the American Medical Association, the American Psychological Association, the American Psychiatric Association, the American Academy of Pediatrics, all of these organizations are saying that this is care that is supported, and yet you're saying you don't trust them either. So I think what the gentlelady is saying is she's the only one that can be trusted to make the decisions. The Republican Party is the only one that can be trusted because you can't trust the parents and you can't trust the medical associate. Is that your understanding as well?
I think we all have to trust Marjorie Taylor.
Mr.
Gentleman yields back.
Mr. Chairman?
The gentleman from Missouri is recognized.
Yes, Mr. Chairman, without objection, I would like to enter into the record a systematic review of outcomes of hormonal treatments in youths with gender dysphoria from the Karolinska Institute in Sweden.
Without objection.
The independent review of gender identity services for children and young people by Dr. Hilary Cass, also known as the Cass Review from the UK.
Objection.
And the treatment of pediatric gender dysphoria, review of the evidence and best practices from our own Department of Health and Senior Services dated May 1st, 2025, all of which refute the outdated, bogus, and methodologically biased so-called science embodied in the so-called WPATH and Dutch protocol. And finally, I'd like to introduce a consensus statement on the management of intersex disorders by Hughes et al., published in the Archives of Disease in Childhood. Too many times our Democrat colleagues like to conflate the idea of gender identity with these unfortunate children who have genetic sexual birth defects, and that likewise I would like to, without objection, enter into the record.
Without objection. The chair recognizes the gentleman from Alabama.
Thank you, Mr. Chairman. I'll yield to Ms. Hageman.
Thank you. I just want to read the current statute, 18 U.S.C. Section 116. Whoever knowingly, being the parent, guardian, or caretaker of a person who has not attained the age of 18 years, facilitates or consents to the female genital mutilation of such person, and then it goes on, shall be fined under this title, imprisoned not more than 10 years or both. Again, this was a bill that was authored by Representative Sheila Jackson Lee. So obviously, and it also goes on to say in subsection C, it shall not be a defense to a prosecution under this section that female genital mutilation is required as a matter of religion, custom, tradition, ritual, or standard practice. So obviously, Representative Sheila Jackson Lee recognized that there were circumstances under which the parents also could be actually guilty of doing things that were really not in the best interest and were very destructive to their children. So again, I'm just reading from 18 U.S.C.
Would the gentlelady yield?
In a moment, I will.
Okay.
18 U.S.C. Section 116, Representative Lee obviously recognized that there were circumstances where it was actually not only did she not trust the parents, she thought that they ought to be prosecuted for having their child doing female genital mutilation on their children. So when you say we don't trust the parents, for the most part, I do trust the parents, I do. But I think that there are also circumstances where I do not believe these kinds of life-altering decisions should be made by minors. As they are adults, that is a different circumstance. But we are talking here specifically about minors, and I think it's very important that we not conflate the two. So again, the existing statute that we are amending would fine and imprison parents for kind of the same thing. So
Would
with that,
the
yes, I will
gentlelady yield? I would just wanted to know who, if the parents shouldn't make these decisions, who should? I mean, who gets to make the decision?
Well, the bill says that we cannot do these treatments on minors.
So no matter what a
the
parent
purpose.
thinks,
That's right.
this bill would not allow parent decision about gender-affirming care as it relates to their children in consultation with their doctors.
It's specifically defined in the bill.
Yeah,
That's
so,
exactly
but for
right.
gender-affirming care, as you talk about
That's
it
exactly right.
in the bill, you're saying parents would not be allowed and would actually have to allow the federal government, would have to yield to the federal government saying, the federal government is going to make all these decisions about anything that qualifies as gender-affirming care.
Anything that's identified and
Right,
defined in this bill.
and are you aware that in gender-affirming care, are you aware of the things that are contained within gender-affirming care?
Yes, I am.
Okay, so you know that counseling and mental health is part of gender-affirming care, correct?
That's not what is, that's not what's forbidden in this bill.
But it is a part of gender-affirming care. You have a very
That's not what's
broad,
forbidden in this bill.
but you have a very broad.
That is not what's forbidden in this bill. Don't distort what's in the bill.
I'm not.
Don't argue with me
Time
by
belongs
distorting
to
what's
the
in the
gentlelady
bill.
from Wyoming.
So can I engage with another question here with you?
Yes, as
Okay,
long as
great.
you don't distort what's in the bill.
No, I'm not going to. I'm going to go back and find the references for what I'm talking about. You talked about female genital mutilation, but your own bill defines female genital mutilation as any procedure performed for non-medical reasons. So in your own bill, you are recognizing that medical procedures are not contained within the definition of female genital mutilation. And yet now you're expanding that definition. And I gotta say, if Sheila Jackson Lee were here, she would, I don't know how to recreate how she would be. I think she's probably rolling in her grave right now. God rest her soul.
You know,
because
she's not
she
here.
was
What I'm doing
talking
is
about
just
something
going on
very
what she wrote.
specific.
I'm just going on what she wrote.
But your own bill makes the distinction of what female genital mutilation is, and it doesn't apply to this. So I yield back.
The bill here is very clearly genital and bodily mutilation of a minor, chemical castration of a minor. That is what is prohibited by this bill. That's what's prohibited. So you can't bring in all of these other things and pretend that they're in this bill, because they're not. That's what's in this bill. That's what this bill
prohibits. The gentlelady is actually the one who's bringing in a lot of things that are not contained in any medical definitions and assessments. In fact, you introduced definitions that we're not even sure where those came from. I yield. If the time is done.
Gentlelady yields back. The gentleman from Alabama yields back. Question occurs. Gentlelady from Vermont.
Thank you, Mr. Chair. You know, what I find in these conversations, and we've had these debates over transgender Americans repeatedly in this committee. And inevitably, it comes back to somebody on the other side of the aisle hurling invectives at us, saying that this is left-wing ideology. And I just want to bring us back to a hearing that we had on transgender Americans in this committee, in which sitting at the table there was a woman who identified as a conservative Republican Christian. That's how she self-identified. And she was saying to all of you who were on the committee at that time, it was last Congress, and she basically said, why are you up in my business? Why are you trying to make decisions for me and my child? And earlier today, and I know we've been here a long time, earlier today, my colleague, Mr. Roy, said, you know, we shouldn't be busybody legislators all up in everybody's business. And he said, we already have too many damn laws. What are we doing here? And I'm just sitting here thinking about the courage that it took for that woman to come here to say to all of you, a Republican Christian conservative, that this actually isn't about politics. This isn't about party. This isn't about left-wing ideology. This is about her job as a parent, making sure she's getting the health care that her kid needs and deserves. And she was completely and totally open with us about the kind of despair that her child was in, the kind of anxiety and depression her child was racked with. And she said it was difficult for her. It was difficult for her and her family, especially in the community that they lived in, to stand with their child and to make this decision. And so I've just had it. I've had it with it constantly coming back to somehow that this is a Democratic issue. There are transgender people living in every single district here, and they identify as Republican and they identify as Democratic, and some of them don't vote at all because they can't stand that their government is being weaponized against them. So can we stop this nonsense? You want to have control over our conversations with our doctors. You want to meddle in the relationship that parents have with their child and with their doctors. It is so difficult week after week after week for you to continue to attack such a small minority of people in this country, and you claim that this is about a partisan issue. It's not. It's about being able to get the health care that their parent deems is necessary to keep them alive. I do not know why, with all of the issues that we have in healthcare right now, from the price of insulin to the fact that we are rolling back all the work that was done on inhalers, to PBMs, to the fact that healthcare systems across this country are falling apart, that this is the topic, once again, that you choose to take up. That this is what we're spending our time at. And I can tell you, because I talk to parents, not just in my district, but who reach out to me who say, thank goodness someone is standing up for us in that committee, because once again, they're demonizing us and dehumanizing us and the language that they're using. Thank goodness you're standing up for us. They can't stand the fact that their own government is spending precious time in committee once again, weaponizing government against them, and they just want to get the health care that they need and deserve. I yield back.
Back, gentleman from California is recognized.
Mr. Chairman, I've been pondering the question that the gentlelady from Washington posed. What would we not do for our children? That's an important question. Well, for one thing, we would not mutilate them. When I was 6, I wanted to be a pirate. I was fortunate enough not to have parents who would have removed a leg and an eye so that I could feel better about myself when I was a child. I don't think I would have felt the same way turning 18. So yes, parents are the fundamental custodians of their children. They have a fundamental right to make the decisions over their children's welfare, health, and upbringing. But there are certain things we don't allow parents to do. You can't starve your kids to death. You can't beat your kids to death. You can't withhold life-saving procedures from your kids. Such acts are considered child endangerment. And if you cross that line, society steps in to protect the basic welfare of the child. Now, that all changes at 18. We've decided as a society that at 18, you can now take control of your own welfare and your own future. Your parents no longer control your welfare, and as a society, we no longer act in place of your parents on these questions. At 18, you're a grown-up. If you want to be a pirate, you can be a pirate. All you have to do is find a doctor willing to take off your leg and poke out an eye. There are cases of grown-ups who choose to be lizards. They have their tongues split, their horns implanted, and all sorts of other mutilations that wouldn't be permissible even if the parents decreed it. But at 18, if you want to be a different sex than you are, you can be. At 18, these decisions pass to you. But until then, we give broad latitude to parents as long as their decisions do not imperil the life of the child or expose them to permanent life-altering deformations. And this is such a matter, and it stuns so many people that the Democrats can't see that. I yield back.
Gentleman yields back. Gentleman from Georgia is recognized.
Thank you, Mr. Chairman. I rise in opposition to the bill, and I also yield my time, or yield some time, to the gentlelady from Washington.
The question on the table is the amendment from the gentlelady from Washington.
Yes, which I know Mr. Johnson supports. Thank you so much for yielding. Mr. McClintock, I think you were saying that if a parent makes a decision in consultation with their kid's doc could be considered mutilation. And I think the examples you gave don't reflect the reality, because you talked about beating kids and things that all the medical associations agree are abuse of kids. What you're doing is adding a word here, mutilation, to your perspective of what gender-affirming care is. That is just your perspective. It is not medically based fact. And I think you have to consider, and I think the Republican Party has to consider the struggle that you're having right now about the size and scope of government. And I think the conservatives are losing. You're certainly losing on the size of spending, because you kicked 16 million Americans off of health care, cut nutrition assistance by $300 billion, and set up massive cuts to Social Security. Also, you could give $5 trillion in tax breaks to the wealthiest billionaires and corporations, and oh, by the way, increase the deficit by trillions. And at least my friends, Mr. Massey and Mr. Roy, are consistent on this. But with this bill, you're really in very dangerous territory, because the party that believes in individual rights and parental rights wants big government to get right in there between a parent and their child's doctor and assign words that have no medical basis to procedures that you simply don't like. You don't like them. You don't want them for your kids. I get that. Listen, this was all pretty new to me when I first started to learn about it for my own family's personal reasons. And there was a lot to learn. And I would say to all the Americans out there, I empathize with something that is new and that Republicans are just doing everything they can to scare you. And so talk to people, read actual studies, don't listen to them. Like, go and research what gender-affirming care is. Find out that, first of all, it includes lots of things, and they are all care that has been approved by major medical organizations. And understand that surgery is a very tiny piece of it. That's what we spent most of this time talking about on this committee. But at the core, this is a cruel, cruel campaign of misinformation, of fear-mongering, of distorting what healthcare looks like for a population that is less than 1/2 of 1% of all Americans. That's what we've spent this whole time talking about. And so I want to go back to what my amendment would do. My amendment would allow medical professionals to continue delivering health care to young trans people when it is considered a best practice. And my amendment recognizes that that care is safe, it's widely accepted, it's appropriate, it's medically necessary, and most importantly, it allows transgender people to live safely and authentically. Now, I can tell you for a fact that these decisions about care in trans families are made really thoughtfully and with a lot of debate and discussion and deliberation. And all of the trans young people that I know, and I know many of them, go through months or years of consultations with their parents, with their medical providers, before they're even able to access care. And there is no standard of care out there that recommends any medical interventions before puberty. So I would just say to people who are afraid, I understand why you're afraid, because my colleagues on the other side are doing everything they can to make you afraid and to try and blame trans kids for every woe that you face. And let me tell you, trans kids did not raise your rent. Trans kids did not make your grocery prices go higher. Billionaires did. Millionaires did. Republicans who continue to funnel tax breaks to those people did that. So just leave our kids alone and let parents make the decisions that they need to make about their kids' health care with their doctors, by themselves, without big government making those decisions for them. I yield back.
No. In opinion of the chair, the noes have it, and the amendment is not adopted.
Could we have a recorded vote, please,
Recorded vote being requested. The clerk will call the roll.
Mr. Jordan?
No.
Mr. Jordan votes no. Mr. Issa? Mr. Biggs? Mr. Biggs votes no. Mr. McClintock? Mr. McClintock votes no. Mr. Tiffany? Mr. Massey? Mr. Massey votes no. Mr. Roy? Mr. Fitzgerald? Mr. Klein? Mr. Klein votes no. Mr. Gooden? Mr. Van Drew? Mr. Nels? Mr. Moore? Mr. Moore votes no. Mr. Kiley? Ms. Hageman? Ms. Hageman votes no. Ms. Lee? Mr. Hunt? Mr. Fry? Mr. Grothman? Mr. Grothman votes no. Mr. Knott? Mr. Harris? Mr. Harris votes no. Mr. Onder? Mr. Onder votes no. Mr. Schmidt? Mr. Schmidt votes no. Mr. Gill? Mr. Baumgardner? Mr. Raskin? Mr. Raskin votes aye. Mr. Nadler? Mr. Nadler votes aye. Ms. Lofgren? Mr. Cohen? Mr. Johnson? Mr. Johnson votes aye. Mr. Swalwell? Mr. Liu? Ms. Jayapal? Ms. Jayapal votes aye. Mr. Correa? Ms. Scanlon? Mr. Neguse? Ms. McBath? Ms. Ross? Ms. Ross votes aye. Ms. Ballant? Ms. Ballant votes aye. Mr. Garcia? Mr. Garcia votes aye. Ms. Kamlager-Dove? Ms. Kamlager-Dove votes aye. Mr. Moskowitz? Mr. Goldman? Ms. Crockett? Mr. Chairman, there are 8 ayes and 12 noes.
The amendment is not adopted. Who seeks recognition? Gentlelady from Vermont is recognized.
I have an amendment at the desk, Mr.
Clerk
Chair.
will report. Point of order reserved by the gentleman from Arizona.
Amendment to the amendment in the nature.
Without objection, the amendment be considered as read. The gentlelady from Vermont is recognized to explain her amendment.
Thank you, Mr. Chair. I want people to understand what's going on here today. My colleagues on the other side of the aisle are continuing their obsession with being in your kid's pediatric appointment. I find it insulting and creepy. And it's astonishing that we are allowing this even to come before the committee today. It's an attempt to interfere with your healthcare decisions for your kids. Essentially, what's going on here is they want to criminalize healthcare. These are decisions that should be made by doctors, by parents, by trans young people, not by, with all due respect, by Mr. Jordan, the chair of the committee, or by any other member of this committee. And we've been in this committee hearing today talking about the incredible amount of federal crimes on the books, and yet we are sitting here talking about adding another one for no good reason. As I alluded to earlier, this has absolutely no business in front of the committee. We have other really important work to do here, whether it's on prescription drugs, whether it's on lowering the cost of insulin, or, as my colleague said from the state of Washington, pushing back against incredible corporate greed and corruption in healthcare. These are all things worthy of our attention. In fact, these are the things that our voters want us to be focused on. But once again, no, we are here. We are beating up on trans kids and their families, and we are trying to criminalize doctors and parents. My amendment strikes the bill's prohibition on providing health care to trans youth. That's what we're talking about. We do not need to be criminalizing doctors or parents for doing what they feel like is in the best interest of the child. We need to be focused on things that our constituents are clamoring for, which is protecting Medicaid, which is making sure people have health care and food assistance. And it's frankly pretty incredible that we're here today doing this just a few weeks after, as far as I can tell, every single member except for Mr. Massey over there voted to kick some of their constituents off Medicaid and by extension shut down rural hospitals as they lose those Medicaid dollars. And if you think that we won't all be impacted by massive cuts to Medicaid, you're wrong. It will impact the doctors, the hospitals, the communities. And this isn't new. We know that this is something that President Trump went after in his first term, proposed cuts to Medicaid. That was the plan. It continues to be the plan. And if you think you won't be impacted by Republicans wanting to make medical decisions for your kids and for your family, you're wrong too. My Republican colleagues have no business being in the doctor's office with your kid. Now, this bill is an attack on parents and doctors and on kids. This bill would throw parents in jail if they help their transgender child access evidence-based treatments. Throw doctors in prisons for providing medically necessary life-saving care to transgender youth, care supported by every major medical association in the United States, and strip parents of their right to make medical decisions about their own kids' health care. I mean, really. This is what requires our attention today. We've sunk this low. We've sunk so low to jailing parents for trying to do what's right for their kids. Parents and doctors already have to worry about state laws banning medical care for trans kids. This bill would introduce the risk of federal criminal prosecution for basic medical care. And let's not forget the hypocrisy of all of this. The hypocrisy of banning medical care for trans kids while permitting that very same care for everyone else. Apparently, my Republican colleagues don't have a problem with puberty blockers or hormone, only with the trans people who need them in order to live. It's cruel, as many people have said today, it's cruel. And there's no medical evidence. Hatred, it is bullying, and it's rotten through and through. And this amendment strikes at one of the worst aspects of this truly reprehensible piece of legislation, and I urge my colleagues to support my amendment and keep Republican congressmen and women